Lords, we had informed the other side is also here. There were advanced settlement talks on. So could your lordships have it on another date, my lords, because we are already in settlement talks in item 46.
After 4 weeks?
After 8 weeks, my lords, could your lordships give a date? A date would help, my lords, because that puts a certain pressure on both the parties too.
Parties are exploring the possibility of some settlement. The learned counsel appearing for the parties are quite confident that parties may be able to reach to some consensus, post it after 8 weeks on a particular date.
My lords, I
Lordship may
request for
mention-
interim orders to continue because they were till today, my lords.
Interim orders to continue.
Your Lordship, may I mention, Your Lordship? Because Justice Vishwanathan, yesterday he was supposed to file written argument. Because of the technical glitch, I could not upload that, Your Lordship, permissions. In that.
Your Lordship, may I mention Civil Appeal number 10114 of 2025? Your Lordship, this matter was supposed to come.
It's on board today.
No, Your Lordship, this is for urgent listing on Monday. It was supposed to be listed after 3 weeks. It was there in the advance list on the 9th of September, but it did not make it to the main list.
The urgency.
So, Your Lordship, the urgency is that the matter is listed before the NCLT on the 16th of September. And Your Lordship said,
It's a
direct.
fresh matter.
Your Lordship, it has been listed once, but Your Lordship had directed settlement, but the settlement did not go through.
Okay, notify it on Monday.
His Lordship permission, may I mention item 4, which is listed before your Lordships on Monday, my lords. This was mentioned by Mr. Anupam Lal Das last week.
Monday, mention it on Monday.
Just my humble submission, my lords. 2 applications are listed by R1. I'm also praying I'm for R6. I have a similar application. That application may also be listed along with them.
Okay.
Great, my lords. I'll just
Lord,
give
item 37, in today's list, Lord, item 37, your Lordship will recall this is that sinking fund matter for DVC, and this is actually having a tariff effect on all the subsequent years. We had mentioned it earlier also, Lord, it was listed today. Unfortunately, today your Lordships are not able to take this. I'm only praying, Lord, then a fixed date be given so that it could be taken up at the earliest, Lord.
Keep it
It
on,
affects a large number of consumers, Lord.
keep it on any Tuesday.
Top of the board, Lord, high on board,
Top of.
deeply obliged, very deeply obliged.
May it please your lordships. My lords, this is a matter wherein your lordships had already directed for clubbing of FIRs. So what your lordships had done was, your lordships had done segregated state-wise. For every particular state, your lordships had indicated one particular FIR to be a principal FIR, and all subsequent FIRs were directed to be merged with the principal one. And there was also one more direction passed by your lordships, wherein, if I may take your lordships to page 22 of the application, lords.
What is the problem? What is the problem?
Lordship, I am appearing for state of Maharashtra only. The issue is regarding Maharashtra, Chhattisgarh and Madhya Pradesh. I am appearing for Maharashtra. Lordship, that they are saying that subsequent FIRs also the special court is insisting on regular bail. So Lordship, I was requesting in respect of Maharashtra, I'll need a
Now
1 week time.
come to the order of 2022, 13th of July, 2022. There was one FIR in West Bengal, one in Rajasthan, 3 in Maharashtra, 3 in Madhya Pradesh, about 7 in Chhattisgarh.
Yes, sir.
Now there are few more FIRs.
A few more FIRs.
Calling for order.
Ah.
They are insisting on 11 separate channels. 3 states. We can ask the 3 standing persons to appear on Monday and follow our order implicitly. Maharashtra, Madhya Pradesh, and Chhattisgarh.
You appear for?
I am appearing for Maharashtra.
Why are you insisting for separate charge sheets and all this?
Separate, Lordship, the court is insisting on,
To the purport of order
yes, Lordship, I,
dated 13th of July 2022
Yes,
or not?
yes, yes.
Are you going to make your officers understand, or we call them here and make them?
Lordship, I was requesting for 1 week's time. I'll file my reply to this because I will have
Heard, Mr.
Aditya Pandey for Maharashtra only.
Not you, sir.
S. Devabrat Reddy, my lords.
So and so the learned counsel appearing for the, this is an MA,
MM, my lords, applicant,
for the applicant, original petitioner,
original petitioner.
and Mr.
Aditya Pandey for Maharashtra.
learned standing counsel appearing for the state of Maharashtra. Prima facie, it appears that the state of Maharashtra,
But Chhattisgarh and
state of
Madhya Pradesh-
Chhattisgarh and state of Madhya Pradesh
If I may clarify, Milord.
have not,
If I may clarify, as far as bail is concerned, state of Chhattisgarh and state of Madhya Pradesh have given their release orders.
Ah.
It is only the state of Maharashtra which is holding on to the release order. And however, with respect to the clubbing, the matters have been transferred. So all the matters have been transferred to one court premises. There are separate trials going on in the same premises. So it's not clubbed.
That's why the three states council.
Yes,
is
Milord.
here, no?
Yes, Milord.
That's what.
क्या लिखा आपने? State of Maharashtra, state of Madhya Pradesh
Chhattisgarh.
and state of Chhattisgarh have not understood the order passed by this court dated 13th of July 2022. It further appears that the directions issued in the order dated 13/7/2022 are being flouted. Today, the Learned Counsel appearing for the state of Maharashtra is present. We grant him 1 week time to take appropriate instructions and come back. We issue notice to the state of Chhattisgarh and state of Madhya Pradesh. Dusty permitted. You serve it to
Milord, I'll do that.
the standing council,
Milord.
right? Notify it on next Monday, top of the board.
Grateful.
You make him understand what is your problem.
Milord.
Next matter.
Grateful.
Grateful, Milord.
Please, my lords. No, Jude, your lordships, give me a passover in this matter.
Pardon?
My lords, I am seeking a passover in this matter.
Why?
The ASG is appearing and he's.
Today we are only in the first half
I'm so sorry.
and there are about 70 matters
Your lordships, call this next week, my lords, if not.
next Monday.
Very grateful. I'm so sorry.
Have you complied with this order of refund, Mr.
We've
Chandrasekhar?
paid it at the time of admission on 10 January itself. We have paid the amounts. It's a question of jurisdiction that we are raising in this matter.
It appears the relied upon order SLP is dismissed. Mr.
Again,
Chairman.
on low tax effect.
That was on no tax.
During, my lords, that Lokpal week, it got dismissed on low tax.
Please, your lordship. Just a 1 minute.
But the
I know.
High Court has followed Bansal. It's wrong.
Once and. But it,
In
it
the
has followed.
item number-
Yeah, it has followed the ruling in.
Oh, it's a different matter. Item number 3.
Yes, ma'am. Please, ma'am. Just 1 minute factual background. I know there's a question of maintainability, but I need to tell your lordship a key fact here. I am the liquidator in a
Sentence.
yes.
Let's try to find a way out.
You want only expunction of the remarks in the order of the NCLT.
Of the NCLT, I'm
So
obliged.
far as that is concerned,
Yes.
that is not an appeal in contempt.
Yes.
It is a regular appeal. That's your contention.
What I was suggesting to your lordship was that Midnapur doesn't strictly deal with this.
No, Midnapur is SLP, but principle will apply, you are saying.
It may not apply because there are 2 stages of appeal. So does the NCLT constitute an intra-court appeal is a real question in that sense.
Substance, that's a rolled up order. It's an
Yes.
order in contempt as far as the party is concerned. As far as you are concerned, it's an expunction order.
It's an,
Appeal should die. Notice.
Issue notice.
I'm obliged.
Issue notice.
I'm appearing for R1 lordship. I'm appearing for R1 in the matter.
He waives for R1.
It is lordship. Lord, on the merits, my lords are granted leave in the against the same judgment. But my lord, I must point out, my lord, there is a delay. My lord, there seems to have been.
637 days.
I'm sorry, my lord.
637 days.
Yes, my lord. Now, my lord, the reason is this. My lord, some officials seem to have proceeded on the basis that the state need not be agreed. But my lord, the problem is.
Will issue notice on delay also
Very well.
in the main matter also and tag it.
Lord, may I
Very
take a suggestion? Would your lordship have a look at the application for continuation of delay?
Yes.
These 2 lines.
No,
You
we have
comment
filed
and
a,
think.
we have filed a more detailed
This
affidavit.
is not for 6:30.
We have not
On
gone
the more why need to look into it.
Y'all can argue. Y'all can argue that delay should not be.
I know that. But leave it. Lord, I don't want to take cold to Newcastle, but I rely on his lordship Justice Padiwala's judgment. Lord, this is how delay has to be explained.
My lord, I'll be like,
This was a,
We'll look into it. We'll look
grateful.
grateful.
Right.
Wait, please, my lords. My lords are considering the same issue, my lords, against the impugned order in a host of matters.
Tag it.
Very grateful.
My lordship, can this be listed on Monday, please?
Why?
My lordship, the double AG is not available today. It's an important question of law.
There is a relied upon order which is lying in defect. Have you seen that?
My lordship, apologies.
This order relies upon another order.
This relies upon, this is against the division bench order of the writ petition.
Have you seen it? It relies upon an order in writ appeal 100532. We have checked up that you have filed an SLP and that's lying in defect.
My lordship, I'll check it. It can be listed on Monday. I'll get it.
You get that matter cleared from the registry, remove all the objections, and notify this matter with that matter after 2 weeks.
Obliged, my lordship.
My lord, the petitioner herein was the original defendant in the original suit, my lord. The suit of the plaintiff was dismissed. The counterclaim of the defendant was also dismissed, my lord. My counterclaim was dismissed only on the ground.
Why do you say 53A will not apply?
My lord, 53A will apply.
There is an agreement.
Yes, lordship. I agree. I am the defendant. I am the defendant.
Huh?
It is in my favor, my lord. It is in my favor. But my counterclaim was dismissed only on the ground that the
What
suit
was your counterclaim?
claim was that the plaintiff should be evicted from the premises. Plaintiff should be evicted from the premises, my lord.
You claim to be in possession,
Yes, lordship.
and by virtue of 53 capital A, the court has protected your,
Yes, lordship.
although the final relief of specific performance has not been granted.
Specific moment was never sought, my lord. It was never sought. This relief was never sought, my lord.
Then who is in possession?
I am in possession.
Then
only-
why are you asking
Yes,
the plaintiff
yes,
to
Part-
evict?
This is a big building, my lord, big house. Part of it is occupied by plaintiff. Part of it is occupied by plaintiff. I wanted eviction of the plaintiff from that particular portion of the,
On what ground?
yes, lordship, on the ground of a settlement between a family settlement between the parties.
Was it placed before the
Yes,
court
lordship.
below?
That is at page 69.
And how the courts have dealt with that settlement part?
Yes, lordship. They say that this settlement
Mhm.
was not a registered document.
But it was in the form of an arrangement. It's not a family arrangement.
It was a family arrangement, my lord.
Family
Yes,
arrangement?
sir.
Are
It
you
was-
all
It
related?
was, yes, we are brothers, my lord. We are
Brothers.
brothers. We are brothers.
There is also a dissolution deed.
Yes, lordship. That preceded the agreement, my lord.
Issue notice.
The partnership, when it is dissolved,
Yes, lordship.
properties need not be conveyed in
Convey. Yes, lordship.
a donkey or something. Yes.
Obliged, my lord.
8 is Bengal entry tax.
Yes, brother.
Tag it.
Your Lordship, similar SLP arising out of similar facts, impugned order has already been dismissed.
Yes, we have noted it. Dismissed. Next
Obliged.
matter. High Court has asked you to avail civil remedy before the court, right?
May please, Lordship. Lordship, my transfer of petition was dismissed, Lordship. I filed a transfer petition to transfer my suit from one court to another court. Your
Why?
Lordship.
Why?
The reason is, Lordship, the defendant is a senior counsel, Lordship, who is having a 50 years practice in that particular court, Your Lordship.
Wrong, but he's a good man, he got a cooperation. Family members, no?
Family member.
Main suit is between family members.
Yes, Your Lordship. And he's a different.
Take down. We heard Mr.
Sabarish Subramanian.
the learned counsel appearing for the petitioner. Prima facie, we do not find any good ground to interfere with the impugned order passed by the High Court. However, we want the parties to explore the possibility of arriving at some settlement. Issue notice for this purpose. Next matter.
Stay may be granted until then, Your Lordship.
Stay of what?
Stay of the suit, Your Lordship.
In the meantime, the further proceedings of civil suit number
OS number 331 of 2023.
shall remain stayed.
Obliged.
Even my lords is Tola.
Tola.
We have the order. Can hand over the order.
But there are 4 points, Lord. Lord, on 19 November, the High Court finds prima facie merits in my case that there is a violation of natural justice. It issues notice, stays the assessment order.
Assessment order is passed.
Lord, there are
You
4,
have
Lord, no
remedy.
personal hearing, my lords.
No, sir. Dismissed.
Lord, there is a demand of 3.2 crore. I am a senior citizen, my lords.
That doesn't permit you to
Lords,
invoke the writ
3
jurisdiction
days
of
time
the
given to issue show, my lords, to file reply.
Take up all these contentions.
Lord, then may I seek one indulgence, my lords? My lords, may I exude time to file appeal in this matter.
Having heard the learned counsel appearing for the petitioner and having gone through the materials on record, we see no good ground. We find no good ground to interfere with the impugned judgment and order passed by the High Court. The High Court declined to entertain the writ petition on the ground that the final assessment order has been passed and the remedy now available with the petitioner is to file a statutory appeal. Full point. Since the petitioner was pursuing his remedies before the High Court, we grant him 4 weeks' time to prefer statutory appeal before the CIT bracket A under the Act. Full point. It shall be open for the petitioner to raise all legal contentions available to him before the CIT bracket A. Next point.
I'm deeply.
So I am the purchaser, plaintiff in a suit for specific performance which was decreed by the trial court, reversed by the High Court in the impugned order. Now, there are 3 findings that the High Court gives in the impugned order. Plus, before that, my sellers, D1, D2, D3 are 3 brothers. I wanted to purchase all the 3 properties that they own.
Come to page 9.
Page.
Look at the 3 points of consideration.
Let's.
Whether the agreement of sale dated 14/12/2004 is valid.
And binding.
Look at number 2.
Whether the plaintiff is entitled to a degree of specific performance, whether the judgment decree of the trial court is sustainable in law and facts.
Now come to page 11.
Page 11.
Read small d.
Millets. Thus, it is clear from the terms of the agreement that the defendants have agreed to term the purchaser, that is, the plaintiff shall pay the amount in respect of the property to the government in case the government issues such direction. It was further agreed upon the sale deed will be executed within period of 6 months, irrespective of the fact as to whether the government grants permission so and lease deed under Exhibit X16. GOMS 46 is the policy decision of the government to make the leasehold hands into freehold on collecting certain amounts. May I just pause here for a minute?
And now G for geography.
In the present case, there was a specific term laid down in the agreement of sale stating that even if the defendants fail to obtain the permission of the government to convert it into freehold property, and if the purchaser is willing to buy the same, still the sale deed can be executed.
What is wrong with this finding?
The GO 1 minutes, the agreement to sell is 14th December 2004. The GO comes later, Milots, which is not even noted by the High Court.
Okay,
High Court.
one more paragraph for you.
May I just
come to page 25.
In view of the foregoing discussion.
In the present case.
In the present case, the factual matrix is in such a way that the plaintiff also knows about the limited rights of the defendants over the suit scheduled property. Further, the defendant number 3, who is the appellant herein, has denied the execution of the agreement, etc. Plus, may I just pause here for a minute, Milots? D1 and D2 are his own brothers. They say they signed the agreement. They also say D3 also signed the agreement. The attester, who is their uncle, signed the agreement.
You paid them.
Because I have paid about 20 lakhs to them. Because
there is not even a refund.
There is no refund. No, because more than anything, because your lordship.
Why do you say this agreement is not valid? There is some principle called ex post facto sanction.
Yes, my lords.
So why the High Court says that this agreement itself is invalid?
Because permission has to be taken.
No, there can be a conditional decree based on Chandanvati Maten principle.
That's right.
Specific performance subject to obtaining permission. These things called fallback.
Is there any statutory provision which prohibits entering into an agreement of sale also? Is there any such provision?
No, my lord, not to my knowledge.
Nay?
No,
Issue notice. You waive the notice.
Yes, my lord. My lord, we have, the consideration amount has been taken back, my lord. They've already
Taken back?
Yes.
no, it's not taken back. What happened was, we had paid an advance of
The
12 lakhs.
deposit may have been taken back.
Yes.
So 19 lakhs we paid in deposit because immediately after the decree in my favor.
We'll look
the
into it.
deposit.
We'll look into it.
The status quo as of today.
My lord,
Third party rights. They shouldn't create third party rights because it's a reversal.
It won't make any difference that third party will step into his shoes. Next matter.
list pendants, my lord, as it is, we will not.
These are small mulgis. They keep inducting.
They are small?
These are small mulgis. Mulgis money shops and the land surrounding that in whole Hyderabad.
Parties to maintain status quo as regards nature, character, and possession of the suit property.
Grateful, my lord. Grateful.
Next.
Deeply grateful.
Items 14 and 15 are TOLA matters, my lord.
Tola.
Much. 15 is also TOLA.
Tola.
The bank had given a loan of 5 lakhs, my lords. Today, it's like a windfall for the borrower where he's now to get 45 lakhs plus interest in compound, my lords. And the foundation of all that is, the allegation is that I played fraud. The fraud is proved only on the ground that allegedly my witness gave admissions. My witness had not even worked as a manager at that time. More importantly, he had only said the documents have all been burnt, because of which I could not produce certain documents before the civil court. On that ground, they said there is a fraud in a counterclaim, my lords. And on that basis, they finally said that I should refund 45 lakhs of a 5 lakh property, my lords.
This interest up to 28th September 2003 will be how much?
My lords,
On 7,90,578.
up to 2003, my lords, the surfacing notice of 26 September 2003 said that the total amount with interest is 7,90,000.
Yes.
After that, I auctioned it. There was a valuer, government valuer, who noted that the value of
All did you auction? Did you
My lords.
auction the machinery also?
no, my lords, it was not auctioned because the auction report is there.
Which findings of fraud in para 19, Mr. Baruch?
Yes, my lords, only on the basis that PW1, my employee, the manager admits. That is what he says.
What else?
No, there are two errors, my lords, with that. One, that there is no admission because the documents on the basis of which this was done, was a fire much time back, is all recorded before the trial court, my lords. That's why trial court is in my favor. It says it all got burnt. PW1 only says these documents are not on record in the bank today. Only that.
Ask documents, you say it is burnt. When you are asked, how did you sell, you are not able to answer.
No, my lords, the sale is there. In fact, I must point out, my lords, I'm just been told about this. There was a list of documents which was produced before the trial court, which included the auction
No, sir.
notice,
No,
possession notice.
As rightly pointed out
My lord.
by my lord, you come to para 19
My lords.
and in the descending order, about 7th or 8th line, it was admitted by PW1, Ram Kumar Gupta,
My lords.
manager, Punjab National Bank, that there is no record with respect to inspection by the bank officials regarding stock. He admitted that Exhibit P16, value of 4 biga, 16 biga was assessed and the reserve price was fixed at rupees 6,30,000.
Lordship, please.
He admitted that plant, machinery, building were not hypothecated, but the same was sold.
But my lords, that
He admitted
My lord.
that the bank under 13-4 took possession of 4 biga on 5/2/2004 without informing any revenue officer. He admitted that before taking possession and after taking possession, apart from notice dated 19-1, no notice was dispatched to the defendants. He admitted that in communication dated so-and-so, there is no mention of taking possession of so-and-so, so-and-so. Look at his admissions.
No tender.
My lords, now may I just respond to that, my lords? I'm grateful. One, my lords, these were not really in the sense of admissions the way it is treated by the Honorable High Court. Second,
What
my
are
lords,
they?
so my lords, what he had indicated was he had worked 7 years after the auction. He had worked in the bank. He had looked into the records of the bank. At that point of time, whatever records were available in the bank, on that basis, he gave that his evidence. One. Secondly, my lords, the documents, and it is already on record, my lords, that most of the documents caught fire. The entire branch was caught fire. It is all recorded, my lords. It is there as a part of, my lords. Kindly see just one page.
When you don't want to produce the documents,
No, my
fire would
page-
save you.
Kindly see page 130.
Sometimes floods would save you.
No, my lords.
Sometimes some any other natural calamities would save you.
My lords, the entire branch was
Why
held.
should we interfere with this?
The reason is this, my lords. May I just indicate? Two reasons, my lords. One, I had made a statement before the trial court about that particular fire, which was also recorded much later in the newspapers, notices, etc. It's not that this was a new thing that I had come up with. Secondly, my lords, there was, and I should have placed this on record, my lords. There's a list of documents I placed before the trial court, which includes, may I just read, the auction notice in newspaper, valuation report, auction letter, authorization of sale letter.
Counterclaim now is decreed for how much? He wanted 45 lakhs.
He wanted, my lords, 2.23 crores.
How much has been decreed?
45 lakhs.
On what basis have they arrived at that figure?
Kindly, my lords, I'm so grateful. Kindly see one page, page 256.
This is Punjab National Bank.
My lords.
2 days back,
I'm
only
aware,
we
my
got
lords.
solid firing from us.
I'm
Very
aware, my
court.
I'm aware.
Something is seriously wrong. Seriously wrong. Such instances are now coming quite often.
May I invite your lordship's kind attention to page 256? How the valuation of 45 lakhs has come.
Yes.
Let me kindly see.
How do you explain this plant, machinery, etc.? How could you have put it to auction?
My lord, it was. May I just show the auctioneer's report then, my lords? Kindly see one. May I just read these few lines, my lords?
Having heard the learned counsel,
Just see 256, please. 256, please. 256.
My lords, may I just read 256?
page 256.
My lords, may I kindly see from the second line. The stock and land was mortgaged in the year 1999. Neither the appellants nor the respondent bank brought on record the collector rates of the property at the relevant time. And in the absence of cogent and convincing evidence, if nominal increase in the price at the rate of 10% per annum is computed, being guesswork, taking into totality of the facts and situation of the property, then definitely the same. If had been properly auctioned, it would have.
Just a minute. Just a minute.
My lords, may just kindly then, just, I understand, my lords. My lords, may just permit me to place these trial documents on record.
No, sir.
This had the auction notice, sales certificate, everything, my lords, which was before the trial court.
We just wanted to look into the quantum of the counterclaim, how it was been fixed. We are convinced.
My
Next
lords,
matter.
the interest on compound, my lords, would come up to 6-7 crores now, right from 2003, my lords. Kindly appreciate this. Compounded interest at quarterly basis.
Just a minute.
I'm sorry.
Back of some collusion, Mr. Counsel. So
At the end of it, my
we
lords.
may issue notice, but at the same time, we may order a probe also. We'll offer you coffee, but the sugar in it will attract too many flies. Are you ready?
My lords, maybe sometimes it is required, my lords, because in the larger context,
Will you have the
it's
coffee?
public money, my lords, which we are.
Will you have the coffee? At your risk. Take down.
My lords, I'll take that risk, my lords.
Prima facie, we find no good ground to disturb the well-reasoned judgment of the High Court. However, we would like to examine whether the amount towards counterclaim has been correctly determined or not. Full point. For this limited issue, let notice be issued. For this limited purpose, let notice be issued. Anything else?
Nothing else. Next, let's see.
Fine. Okay.
I'm so grateful.
Lords may allow me to enter appearance in this. It's my father's case. He's 85 years of old.
So
or disabled soldier.
why did you keep standing in the
Lordship, the
corner
senior
when
told
we are
me-
issuing notice?
My lords, I practice.
All of a sudden you erupt.
No, no, my lord.
It's not fair, sir.
No, no, my lord, the defendant.
You were just watching. If the
No, no,
court dismisses, well and good, I go home.
No, no, my lord,
It's not proper.
my lord, this litigation is going on for the last 21 years.
You waive service of notice.
Lordship.
In your own father's case.
Yes, my lord, he's a war disabled soldier, fought 62.
Advice, don't appear. You give it to a counsel.
My lord, I requested somebody, they didn't turn up.
Don't appear, you file your.
I was not coming also, I requested somebody, they
So
didn't.
now we are issuing this notice for
I
the,
go, my lord.
we'll just examine
Lordship.
whether this amount towards counterclaim has
I've heard,
been
I've heard.
reasonable or not.
All right, grateful.
And don't do it next time.
I'm sorry, my lord. I tender unqualified apology for that. Grateful.
Your Lordship, I'm impugning the order of the Honorable High Court dated 22/5/25. I'll give the brief facts, Your Lordship. In this case, the property in question was bought by Chunni Lal on 13/5/1988, Your Lordship. Now within 30, and he is resident of Delhi. Within 13 days, he gives the general power of attorney to somebody called Kulbhushan Anand, and in the general power of attorney, no ground is mentioned as to why it is being given, Your
Come to
Lordship.
para 14, ma'am.
Please, Your Lordship.
Why is the High Court saying that the factum of GPA and the sale deeds executed have not been disputed?
Your Lordship, that is a wrong finding because even in the written statement, Your Lordship.
Why do you say a wrong finding?
Please, Your Lordship, because in the written statement of the defendant number 2, that is the Chunni Lal, who is the original.
Come to para 15, ma'am. In the original conveyance deed dated 13th May, which had been executed in favor of Chunni Lal, he was in possession.
Para 15, Your Lordship. Please, Your Lordship. Chunni Lal was in possession of, in the original conveyance deed.
And above all, there are concurrent findings of
Your Lordship,
three
now,
courts.
now there is one more issue. The son of this person, Chunni Lal, he himself says that yes, my father, because he is the witness to the sale deed.
Something gross, ma'am, something very palpable, something
Yes.
really that would.
Your Lordship, now in this case, she has filed a suit for declaration. She has filed a suit for possession, Your Lordship. Her title is under cloud, and secondly, Your Lordship, her possession is not there. So a suit for possession alone was not maintained.
Sorry, ma'am, sorry. Dismissed. Next
Your
matter.
Lordship may just, Your Lordship, the GP is also under crowded circumstances, Your Lordship.
Thank you.
May it please your lordships. My lords, this is a suit for infringement. The defendant number 2 is a director, my lords. No, my lords, the wife, by virtue of a will, the shares are today transferred. 87% shares are there in the name of the wife. The wife files an application for impleadment that is allowed on the oral request of the plaintiff. Defendant number 2 is, sorry.
You seem to be in a lot of sorrow.
I know, my lords.
Inconsolable
wail, meriting succor
of this court as a last and final refuge, not vying for any monetary gain, but to salvage her pride, outrightly tarnished due to wrong appreciation of facts by the High Court.
I know, my lords. I know, I said so.
Mr. Tharoor would also have
problems, my lords. I know, my lords, I've seen that. No, the point is, my lords, the SH4 form, which is at page 40. My lords, the will is at page 42, my lords. By virtue of the will, she's the second wife, she gets.
Next matter.
My lords, can I show that SH4?
No, sir. Next matter.
Because, my lords, the company is
you may
sued
be
not
having-
to the director. Kindly
you
see
may
the
be
cause
ha-
title, my lord.
This is an infringement suit. What has a shareholder to do?
So, my
You
lords,
may be having 87% of.
my lords, I am the director of the company, my lords.
All right, next
The
matter.
company in the defendant one, my lords. Kindly just see that and then, my lords, I'll.
Next matter.
Oblige.
Please, your lordship. No, my lord, this is a matter in which, my lord, the document of surrender of tenancy was neither produced nor proved. Your lordship may kindly see page 14, my lord. The High Court judgment, my lord. Page 14, my lord, about middle, my lord. So the trial court.
See, if we have understood it,
with a lot of effort, we try to understand it.
You surrendered your tenancy rights, saying that I want to purchase it.
Then he refused to buy.
And then what, sir?
Now, I'll tell you, Lordship, my lord. Now, my lord, they have filed this suit based on document of surrender of tenancy. Now, my lord, there is an agreement. It is true, my lord, there is a recital in the agreement that it is surrendered. Now, my lord, your lordships have said in one of the cases, a mere recital, my lord, it is a very weak evidence and that can't be solely related.
What else?
You set up an agreement. I but refuse to pursue that agreement and comply with it. What else can I do? It's his property.
Now, my lord, the only thing is, my lord, I am told, my lord, they are prepared to purchase this property, my lord, so matter may be sentimental because they have been occupying this property for the last 70 years.
So I'm on caveat because I don't have any instructions on this aspect because that has fallen.
Maybe a referred for mediation, my lord.
Should we send it to the Supreme Court?
You're ready for mediation?
Having heard the learned counsel appearing for the parties, sorry, we heard Mr.
Romi Chaku,
the learned counsel, senior counsel,
yes, my lord.
appearing for the petitioner.
Yes,
how many petitioners are there?
3
petitioners and Mr.
Kunal Chima, my lord.
Chima, the learned senior counsel appearing for the learned counsel appearing for the respondent.
Both caveats, my lord. Respondents one.
On caveat. We believe that the parties should sit, talk, and try to arrive at some amicable settlement. Parties shall appear on so and so date before the Supreme Court Mediation Center. Okay, next.
Yes, because initially virtually because I don't know the age of the party.
That's the procedure.
Yes, as your lordship. That's come in the order. As your lordship, please. Okay.
In the meanwhile, my lord, status quo may be maintained, my lord. So I'm told, my lord, they are taking steps to evict me, my lord.
With great difficulty, we are issuing the passing this order. Otherwise, status quo would have been over today only.
Yes.
My lords, item 20, my lords, the High Court has declined to look into the arbitrary action of the bank, my lords, as well as more so the ombudsman. My lords, on one hand, they are declining the documents which I am seeking and also holding me responsible for the utilization of the loan.
Should you not take up the matter with the ombudsman?
I've taken it up, my lords.
Then what happened?
They have also, my lords, earlier the bank wrote a letter and they said that we are revoking their responsibility, but they later revoked that letter, my lords. Now the ombudsman has simply said that the bank has declined to pass any order on this. My lords, by their own admission,
how do you invoke the jurisdiction of the High Court?
My lords, the bank is writing letters to the company that the documents are not being provided. These letters are all on record and the High Court did not see all those letters.
Just paragraph 3,
please.
Last 5 lines. The petitioner then approached the ombudsman who has declined to interfere on the ground that the matter involves commercial judgment / decision of a regulated entry. Therefore, it is not amenable to his writ jurisdiction.
My lords, there is fraud on the which is alleged on the part of the bank, my lords, and I have shown the letters.
Why are you not filing a suit?
My lords, that will be against the company. I will be pursuing my remedies against the company, my lords. But against the bank, my lords, I only have remedy.
Guarantee stands discharged, etc., etc. You can raise it. They just be decided no in a disputed question of fact.
My lords,
just be decided.
But what will happen is, my lords, that right now what is happening is the bank is writing letters to the company. They are all on record, and High Court did not see that the documents have not been provided for funding of the loans, but the loans have been funded, and I'll be held responsible, my lords. And that is, these letters were all on record, my lord.
If the guarantee is a conditional guarantee, and if you think you are discharged in the absence of compliance with those conditions, you have to invoke your remedies.
My lords, all I was seeking was, I was asking for certain documents on the basis of which loan was given. The bank is also declining to do that, my lords.
So discovery is there.
Because I am responsible, my lords. I am the guarantor. I am responsible. My personal properties all will be involved in this one. My lords, may I see just one, show one letter, my lords, page 39. This is the letter which is impugned in the High Court, my lords.
But see the prayers to revoke the guarantee given by the petitioner in respect of term loan 1, term loan 2, disbursed by the bank when the petitioner was a director of company, respondent number 6.
My lords, I'm no longer the director now. I'm the guarantor.
Now, what is the problem today? Who is fastening the liability on you?
Bank, my lords, page 39. That's the only document I have to show, my lords.
Page?
39. This is the letter.
Annexure?
Annexure is P7.
P7?
Please, my lords.
What is the date of this letter?
18 January 2025.
What have they said here?
My lords, I'll read from the first paragraph. It said, my lords, that the contents of due to administrative emergencies and workload, I could not reply to your earlier letter dated so and so. However,
So what about your liability when you were a director of this company and the company obtained the loan?
But
you stood as a guarantor, na?
Please, my lords.
How do you want to
I have provided
all yourself from this liability?
I'm not doing that. What I'm doing is, my lords, there is something happening in the company, and I've shown all the documents to the bank. I've given all the proof also, but what is happening, my lords, there is collusion on the part of the bank.
So what do you want us to do?
My lords,
call the bank?
No,
Tell them that you relieve him of his liability.
My lords, what I'm seeking, that there are certain documents which are not being provided to me. I am the guarantor. At least because if they are holding me liable for utilization of
what type of documents?
My lords, the documents are mentioned in the letter dated 31st December 2024. That
show us that letter. Annexure. P11?
P5, my lord.
P5?
Yes.
Let us see.
31, page 31, my lord.
What is the reply to this letter?
This is the 18th January letter, my lords, which has been given to me. Page P7. That is the reply.
What have they said?
They are saying that you are personally liable, but we will not be giving the documents to you. That is what they are saying, my lords.
What type of fraud are you alleging at the end of the bank?
My lords, we are alleging that the loans have been given to the company without following the due procedure, my lords. The documents have not been provided by the company.
So what were you doing when you were a director on the board?
My lords,
You took a policy decision to go before the bank, obtain a loan. You were very much on the board of directors.
I had written letters to the bank from then itself, my lords. I had informed the bank. My lords, my signs have not been taken. Signatures have not been taken, my lords.
Having heard the learned counsel appearing for the petitioner and having gone through the impugned order passed by the High Court, we find no good ground to interfere with the same. Full point. If the petitioner has any serious grievances against the bank, insofar as fixing his liability as a guarantor is concerned, it shall be open for the petitioner to avail appropriate legal remedy before the appropriate forum in accordance with law, including filing of a civil suit before the competent court, before the civil suit. That's all. Next man.
My lords, in the meantime, they will hold me liable if anything, because they themselves are saying that in their letters that the company will be declared NPA, account will be...
Virtually, we are investigating into the matter. Next matter.
Obliged.
Challenging the order dated 6th of...
Matter has reached the final stage of argument.
Final stage of argument.
And you now invoke 73 of the evidence?
Your Lordship, actually, I have filed this application, but
Opinion of FSL?
Your Lordship, kindly have a look at, I took the handwriting and spot opinion, which is at page number 101 to 110. Because these few documents, which is very relevant document, I am carrying the original documents, and actually there are multiple matters going on in different court. And in one...
What were you doing all throughout? 6 years? What were you doing?
Your Lordship, actually, the original documents are lying...
Dismissed. Next matter.
Lordship, kindly see.
Don't bring such matters here. Next matter.
Lordship, I have a small submission, Lordship.
Next matter.
I wish to show only one document, my lord. Page number, annexure P6, page 43, 44. My submission is there, my lord. Before 4.5 months, the document was not available even from the custodian, my lord. For that, I will show, my lord. Page number 43, P6, dated 20th January 2025, my lord. That is written by Assistant Director of Joint Director to Assistant Director, District Town Planning Office, my lord.
Plots, you yourself have 15 plots in
No,
that approved layout.
but
Surrender
not-
it then.
but-
Say not interested.
because he,
We'll see mining is permitted or you have, in the report says you have 15 plots.
but actually, my lord, that was the Pandyan Nagar, my lord, that is in the not this, that's layout, my lord.
Dismissed. Next matter.
Liberty, Lordship may give me liberty to challenge.
No
that order.
liberty. No liberty. Next matter.
Otherwise, that become final, my lord.
Doesn't matter.
We may not have, the High Court may not, whatever the report which has been made, my lord, that may be permitted to challenge it, my lord.
Dismissed. Great matter.
Lordships, here the property was already elaborately pleaded in the.
Then
plaint.
why did you have to invoke this?
Second
Huh?
appeal.
Second appeal? Amendment in a second appeal?
Well, that is permissible, Lordships. But what I'm trying to say is, please see para 12.
Just, what is your problem? The problem is that you were unable to give the description of the suit property.
No.
Yes.
Please see para 12. That is of the plaint.
So what amendment are you seeking?
We just wanted to, the boundaries were not there in the.
So what is it called? In the plaint, how do you show the boundaries of the suit property?
Lot of Order 7, Rule 3.
In the description, na? Have you practiced on the trial court side?
All that was not there was the schedule.
Huh?
All that was not there in the plaint was the schedule.
If the schedule to the suit property is not stated, mentioned in the plaint, how do you expect the court to grant you the decree?
That is what
The
I'm
decree
saying.
will be granted in respect of which property?
That is what I'm trying to say. Please see para 12.
What's this?
Please see para 12 for once, Lordship. Please see para 12 for a moment. Please see para 12 for
Para 12 of what?
of the plaint. The property is already described. All that we wanted to put it is in the schedule. The plaint.
The schedule is empty. You have not shown anything in the schedule.
There was no schedule in the plaint.
Let's
all
see the plaint.
Yes, Lordships. Please
Your
see para
original
12.
plaint.
Please see para 12.
Annexure?
Annexure P4. And please kindly come to page 33.
Okay. Your suit is about?
We were challenging basically two government orders.
Huh.
That is P1 and P3.
Now come to
Para 12 of the plaint, Lordships. Page 33.
page.
Page 33, para 12.
Wait a minute. Read it.
That after formal settlement order as stated above was issued, the plaintiff paid the requisite premiums of sum of so-and-so in the form of treasury challan dated so-and-so for the said land. Thereafter, Jamabandi was issued in favor of the plaintiff for the said land white dated so-and-so bearing patta number 1009, dag number 1134.
Okay. Come to para 23.
Para 23, Lordships.
23 is cause of action,
Yes, Lordship.
right?
Yes.
Then 24 talks about the valuation of the suit.
Yes.
What is 26?
26 is, and this is a mistake on our part. This is not the prayer. The prayer is, the prayer was amended subsequently.
CPC dijiye.
Kindly have a look at the prayer.
CPC dijiye.
Yes.
Read order 7, rule 3.
Yes, order 7.
Read it.
Yes, Lordships. Order 7, rule 3. Where the
Wait a minute.
Lordship.
Wait a minute. Read it.
Where the subject matter of the suit is immovable property. Where the subject matter of a suit is immovable property, the plaint shall contain a description of the property sufficient to identify it, and in case the property can be identified by boundaries or numbers in the record of settlement of survey, the plaint shall specify such boundaries or numbers.
So your case is that you have specified such boundaries or numbers, right?
Yes, Lordship.
Fine. Remain satisfied with it. Dismissed. Next matter.
Lordship, all that we wanted.
You're taking us for a ride. Next matter.
Very grateful.
At the stage of second appeal, you move an application. Next matter.
Great.
20, 24. Yes.
Please, my lords.
Order 9, rule 13.
Please, my lords, order.
After how many years? But sufficient cause was assigned, ma'am. The man was in jail.
50,000 cost also given.
Man was in jail. I think somebody was ailing also.
Milords, if my lords, the trial court as well as the learned appellate court, they have given concurrent finding that he was appearing in the other matters.
Just read one paragraph, 13. What do you have to say?
Please.
Para 13. Is this finding incorrect?
Milords,
Page 5.
please, Milords. The perusal of the record shows that the ex parte judgment and decree was passed on 7/4/2016. The husband of the petitioner was released from the jail on 17/3/2017.
Are you disputing this?
Please, Milords.
Huh?
Please, Milords.
Why? Why are you disputing? These dates are incorrectly recorded?
If my lords may kindly permit me.
No, go by these dates.
Please, Milords.
Judgment and decree passed on 7/4/16.
Please, Milords.
Husband was released on 17th of March,
Please, Milords.
almost 1 month before the, and after his release from jail, he immediately filed application for setting aside the decree 7/4.
Milords.
Actually, there is a mistake. 7/4/16, 17/3/17, and then 31/8/2015.
Sitting the judgment. Next part. Order is 31/8. Decree is 16. He was released in 17.
Right. And after his release from jail,
filed it.
Milords, if may kindly see, Milords,
Yes,
if I
yes.
may,
Next
Milords,
matter.
if I may, Milords, may kindly permit me to show 2 documents, Milords. Milords, he was a.
bother the Supreme Court with such matters. Next matter,
Milords,
please.
kindly see, Milords, page 64.
That's all, ma'am. Next matter.
Milords may kindly appreciate. Milords, the trial court has duly recorded he was not ailing. Milords, on 31st August, when the ex parte order was.
Tested now. Why are you foreclosing a contest?
Milords, I am not foreclosing. Milords.
Just go fight it. You got 50,000 cost.
Milords, 50,000 is for the legal aid, Milords. Milords, 50,000 is for the legal aid, Milords. If my.
Next
Please,
matter.
Milords, page 8. Milords, if I may submit, Milords, one thing, Milords. Milords, if my Milords may kindly appreciate one thing, Milords. Milords.
We will start appreciating all this. Doomed.
Milords, now the execution is going on, Milords. Milords, if I may be protected to this amount, Milords, because the attachment.
See the circumstances explained in what circumstances this ex parte decree came to be passed. Man was in jail. No sooner he was released, he took steps. And it's a discretionary order. Next matter.
Page 43, Milords, in my Negotiable Instruments Act, Milords, he was appearing in the court, Milords. During the same period, he was appearing, Milords.
Somebody was bringing him from the jail?
Yes, Milords.
Who was bringing? The jail authorities were bringing him?
Milords, he was on bail, Milords. In various orders, it has been recorded that he was on bail.
If the facts recorded by the High Court are incorrect, should we send you for review? Would you like to not press it?
Milords, I'll review. I'll go for it.
This, after arguing the matter for quite some time, the learned counsel made a fervent appeal that she may be permitted to withdraw this petition with liberty to move an appropriate review application before the High Court. Full point. Dismissed as not pressed. Next matter.
And Milords, if review order could be permitted.
Thank you. Next matter.
Obliged.
Please, Milords. Well, there hasn't been any intimation to the insurance company, my lords. Courts have given a finding to the effect that the complainant insured only and only informed the bank. There is a letter which the complainant has claimed that the bank intimated to the insurance company, that is me. I have denied that letter.
Special facts. Everything was done through the bank. Everything. That's why the court says on the special facts we are confining this order. That bank was the one which took the policy. Bank was the one which was acting as an intermediary. Who informed he informed the bank. Bank informed you.
No, my lords. My lords, that is what. My lords, it hasn't been the case of the bank at all that the bank informed me. It is the complainant who has averred that in the complaint. Bank has not said so in the WS. If my lords may kindly have the WS of the bank, Bank has not said so in its WS. My lords, may kindly have page 157 for a moment. Starts at 156. It isn't the bank's case.
Come to para 39. Is this finding incorrect?
Yes, my lords.
Incorrect.
Yes, my lords. We have
Why do you say incorrect?
My lords, because the
Factually incorrect?
factually incorrect.
Go to the High Court and say that you have recorded incorrect facts.
Your lordship
Same
kindly,
order.
your lordship may kindly appreciate that this particular
Is this finding incorrect, Mr. Counsel? Second time we are asking you.
change in location was duly intimated to the.
What has been recorded in para 39 according to you is incorrect factually?
The
Yes or no?
Yes, your lordship.
Incorrect.
Incorrect because there was no such intimation.
Let him go.
Please, my lords. My lords, the High Court accepts in its impugned judgment that there is no evidence, no notice, no intimation of any retirement.
He's the daughter-in-law of the
Yes, my lords.
gentleman.
Mr. Sagar, yes, my lords. We have a chart for your lordships. So,
So, according to you, she continued, but they are saying a
Yes, my
86
lords.
deed.
yes,
You are never part of.
yes, yes. But the 76 deed, which is undisputed, says you have to give notice. The forged deed removes her. This is the family tree, my lords. It's a very distinguished law publishing company, my lords. And you'll see, my lords.
What is the petitioner's number two's name?
Vibha Sagar. my-
Vibha Sagar.
Vibha Sagar. And the respondents, my lords, we've shown are all listed, my lords.
Went out in 96. She was never thought of any conflict firm.
Having heard the learned counsel, learned senior counsel appearing for the petitioner, and having gone through the materials on record, we are of the view that the parties should sit, talk, and try to arrive at some amicable settlement. For this limited purpose, we are inclined to issue notice. Issue notice, make it returnable on a so-and-so date. Next matter.
My lords, stay till the next, because assets are being alienated, my lords. The law publishing houses have two very eminent properties, my lords. These are old, because even in Delhi, that's the same thing, my lords,
Right.
universal publishers.
Try to persuade the other
So
side.
they say 27 years, you have had absolutely no concern. We'll see what we can.
Can I just file the petition?
Yes, my lords, also, can we file some additional documents, my lords?
No problem.
I'm grateful. I'm very grateful, my lords. Very grateful.
Sorry.
My lord, this is that matter, my lord.
It will take some.
It will take a little time, but my lord, in fairness to my learned friend, my lord, he has filed an application. I have advised my client, my lord, that we have a duty to be fair to the court. I will deposit 96 crores, my lord, in this court. My lord, I have a duty as an officer of the court.
That's very fair. I'm grateful to my learned friend.
Okay. So now today we resolve one thing. We fix a particular date. On that day, we need to hear this matter. Every time this matter comes up, somehow, some reason or the other.
It's only on interest now.
My lord, it's only on interest pendent item.
Majority supports you, or is majority is only post-award?
My lord,
Balaswamy.
my lord, in fact, my lord, it's post-award. But my lord, if I may say so with respect, 36% with monthly rests for pendent item for an arbitration which took 9 years.
Okay. What statement do we record today?
My lord, I make a statement that
Just a-
I will deposit, my lord, a sum of 96 crores with the
Gopal.
registrar of the court.
Just Mr. Gopal Subramaniam, the learned senior counsel appearing for the petitioner, makes a statement that
My lord, I would make, my lord, a deposit to the
that
satisfaction
his client would make a deposit to the satisfaction
of the registrar Supreme Court. My lord, I would deposit it in court, my lord, a sum of 95.97.
Acha is there any? Mr. Gopal Subramaniam, the learned senior counsel appearing for the petitioner, upon instructions from his client, makes a statement that his client is ready and willing to deposit an amount of rupees 96 crores with the registry of this court within a period of,
My lord, I'll do it in 2 days, my lord.
within a period of 1 week from.
Grateful, my lord.
Let this amount be deposited with the registry within a period of 1 week from. Okay,
My lord, the same can be placed in an interest-bearing account.
that
Very well.
the registry.
Yes, certainly, certainly.
Mr. Shyam Devan, the learned counsel, has appeared on.
That last amount was allowed to be withdrawn by us.
Let him first deposit.
All right, very
Next
good.
step in the process will be.
Please, Mr.
Good for them. Once the amount is deposited with the registry shall invest it in a short-term interest-bearing deposit with any nationalized bank. Mr. Shyam Devan, the learned senior counsel, has appeared on behalf of the respondent. Posted on any NMD, on any non-miscellaneous day, top of the board. Thank you.
Good.
Lordship, in this matter, I appear for the petitioner, your lordships. Lordships, there's a issue pending before the Honorable 5 judges bench. Out of a 3 judges bench who had referred a matter, and the reported judgment is 2025 4 SCC 1. Your
What
lordship,
issue is it, Ms. Shilpi? What issue is it?
your lordship, there was a delay in preferring an appeal before
No,
the
correct,
district
but
judge.
I think the referred issue is on registration of MSMEs, no? Is there any other issue referred to?
Your lordship, the issue mainly is, there are 2 issues, your lordship. The pre-deposit was not arranged, therefore there was a delay in filing the appeal. But your lordship, however, the MSME registration was there.
But your case is so delay in filing the 34.
Yes, your
That's
lordship.
correct.
Yes, your lordship. Your lordship, so I'm just relying upon the judgment that is Your lordship, in fact, substantial payments have been made. Your lordship,
for the respondent caveat.
Your lordship, my instructions are that only an amount of 12 lakhs was pending, which is, however, also supposedly paid, but
That's incorrect.
proofs of the same, your lordship, because there were different regional offices that were involved.
But
So, your
ma'am,
lordship, as on date, the only issue remains is in respect of the interest part, your lordship.
how do we condone the delay?
I completely bow down, your lordship. Only that the issue whether an appeal can be, your lordship, converted to a writ petition.
Where are
before the-
you? Are you in your chamber?
No, your lordship, I'm at home. I had some medical
This red
issue.
light is very strong.
So that's a curtain, your lordship.
Oh, I'm sorry.
Thank
you.
So assist us.
Yes,
How
your
do
lordship.
we condone this? This is subsection 3 of section 34.
Yes, your lord. That there are
90
absolute
days.
provisions. Yes, your
There is
lordship.
a delay of 120 days.
Yes, your lordship.
So how do you
Your lordship,
assist us?
if I can be permitted to file a writ petition, your lordship, in respect of the judgment that is passed by the 3 judges bench in Tamil Nadu Cements versus MSME. Your Lordship,
Facilitation Council would be amenable to writ jurisdiction.
Your Lordship, that's the issue which is pending before a 5 judges bench, Your Lordship. In Tamil Nadu Cements versus Micro and Small Enterprises Facilitation
That's
Council.
exactly what my lord pointed out to you. But till that issue is not resolved, how will you avail the remedy of writ before the High Court?
File and keep it and wait for the judgment.
Your Lordship, my difficulty is substantial amount is paid and my there are execution proceedings pending before the law court, Your Lordship. So I'm just trying to because Your Lordship, the case on merits is good, only that the pre-deposit was not arranged timely by BSNL because of interdepartmental approvals.
What do you have to say, Mr. Petkar?
Yes, Manoj. So far as the admitted facts are concerned, that is not what the reason is. Admittedly, award date is December 22. The certified copy they get in February 23. Section 34 is filed in November 23.
No, that's all
Admittedly.
right. How much have you received and what is the interest as on today?
Well, it's in the MSME interest. The execution petition filed is a specific interest amount. I'll just indicate, Manoj. I have it in front of me.
Received 9 crores.
Manoj, the award says that 10 crores deducted by 9 crores. So as on the date of award, 1 crores along with the MSME interest.
According to you, how much is the interest accrued which you are executing now in the
Yes, Manoj. Manoj, it's 2 crore 81. It's an MSME interest because it's 3 times. The total pending amount is 281.
Your Lordship, my only
And
submission.
my learned friend can always have her objection in the executing court if she thinks the interest is calculated incorrectly.
Miss Shilpi, should you not argue that my client is Bharatiya, what is?
BSNL, Your Lordship, it's a public.
BSNL?
Yes, Your Lordship.
That should be your first argument.
Yes, Your Lordship. I'm Your Lordship, it's all public money. I've taken that ground also, Your Lordship.
Public money is not going to persuade us. Perhaps BSNL may persuade us.
I'm highly obliged, Your Lordship.
Issue notice for the purpose of some settlement. Today we are only concerned with the interest amount, full point, right? Mr. Petkar waives service of notice for and on behalf of the respondent. Should we send it for the mediation? Parties to appear before the Supreme Court Mediation Center on so and so date. Next matter.
Much grateful.
So better you sort it out. Otherwise, if it gets stuck in a writ petition, the earlier judgments also saying these awards are amenable to writ. Rohta's judgment, I remember.
I quite see what is falling from my notes. I'll instruct my clients.
Highly grateful. Highly grateful.
29, my lords, an SLP against the same order, my lords, have issued notice on delay as also on.
Tag it.
Obliged, my lords.
My lords, in item 30, the relied upon judgment, the appeal has been dismissed.
Oh, secure.
Secure. May I hand it over?
Then we'll have to issue. Sorry, relied upon it. Dismissed. Next matter.
Obliged.
Your Lordship, I am seeking pass over, Your Lordship.
No pass over today.
Your Lordship, in that case, can adjourn for the Monday or Friday.
What is this matter?
Your Lordship,
Let's discuss.
this matter is regarding lifting of corporate veil, Your Lordship.
What corporate ways?
Your Lordship.
What? Huh?
Your Lordship, the decree was part ex parte, and I was the director in the company which was struck off.
Tuesday.
Come on.
Lordship.
Monday.
Come on Monday.
Please, Your Lord.
Next Monday.
Deeply obliged.
Please, my lord, more than 2 years undergone 307, my lord. And, my lord, just recently, my lord, a person with a graver role, my lord, is released on bail. My lords may kindly have a look on this, my lord.
The trial has started?
Trial, my lord, I am not an accused in Gutsi talk. I am only an accused in 307. So, my lords directed that in Gutsi talk, the trial be finished in 6 months. There is a stay. as per section 10 of the Good Talk Act, my lord, because
The same matter.
yes, same matter, my lord.
Man was brutally assaulted.
My lord, please see this. Please have a look on this order, my lord. Just recent order, my lord. A man with a graver role who was also an accused in Gussi Talk is, my lord, please see para 6. Kindly have a look at para 6, my lord.
No, that's, here your lordships were pleased, at page 280, your lordships were pleased to dismiss the 307 of a co-accused on merits as well, my lords. Please see paragraph 6 at page 281, at paragraph 6, my lords, at 283. However, the petitioner has not been able to make out any case on merit so far as his plea for bail is concerned, more particularly having regard.
The problem is, last time also we had discussed this issue.
Yes.
There seems to be some provision in that good
Section
talk
10.
Section 10.
That first the trial of good talk should be
Yes, my lord.
undertaken,
Yes.
completed, and then the IPC office.
Yes, my lords.
Now, this man is not being prosecuted for
No,
good
no,
talk.
no, my lord.
So long as that good talk trial is not concluded,
Yes.
he can't pray for bail.
Yes. Because that's dismissed on merits. He has to make out a case on merits, my
Where
lords.
is that order?
Of 281, my lords.
Annexure?
Annexure P17. PDF number.
That windmill problem. That windmill company, na?
Yes, my lords, windmill, the co-accused, the petitioner before your lordships was my guard. In fact, he was to protect me.
And my lord, unknown persons, the TIP, my lord,
and
they said they claimed that before the executive magistrate that the complainant cover Jeet Singh was present and he identified.
283.
And my lord, whereas he was not present.
283.
Please.
Co-accused have now filed a stay application again in the revision.
What is the role attributed to this?
That he was my guard. He was there to protect me. In fact, he assaulted.
This
Graver
That's
role,
under
my
the-
lord. I'm sorry.
This Rajku Bhai,
Yes, assault.
co-accused.
Yes, my lords.
Same type of allegation.
Yes, my lords. But on bail on goods in Gutsi talk, I pointed out your lordship's judgment to the court, my lords.
This man is not
Not for 307. That's on Gutsi talk.
idea in some of the accused for good talk.
Yes, my lord.
Some of the accused for IPC.
Because they
What
had,
is the idea?
because they had other cases as well. If you had a criminal antecedents, etc.
The way, how long should we keep them in?
But my lords, they are the ones who are dealing after this. May I just pass on an order? The accused who are in Gutsi talk now have again filed a revision before the High Court asking for stay.
It is not within this man's control.
But then your lordship's order, my lords, at paragraph 6 dismisses it on merits, my lords.
But then,
And earlier also for co-accused, your lordships had been pleased to dismiss while sitting in a different combination.
see, we have said 15. If that be so, the special court shall start with the recording of the evidence in good talk.
Yes, my lords.
See to it that the entire trial. Now, this order is dated.
Your lordship's order is 16/7/2025.
Now, the problem is that this trial is not proceeding.
No, but please see para 6 also, my lords. Your lordships first dismissed it on merits, thereafter proceeded that the Gutsi talk trial should be completed in 6 months' time. Because that was the argument of Mr. Luthra who was appearing in that matter.
Para 6 of
Now, my lords, in the Gutsi talk, the coordinate bench of your lordship's court, my lords, has been pleased to grant bail to one of the accused persons. That person is not on bail in 307.
Now, we don't think that this Gutsi talk is going to get over in 6
No, it will not, my lords.
Para 7.
Yes, my lords.
Only 2 out of 41 witnesses.
Because now 4, but now there is a petition moved again, revision before the High Court for stay of proceedings. Because they know the idea is not to let the Gutsi talk trial get completed and thereafter move for bail. That's the idea, my lords. Now again a petition before revision. May I pass on this order for
Over and above this man.
Yes,
how
my lord.
many else are in custody?
6?
They have not prayed for any bail.
No, what that came, was dismissed for 2, that was dismissed by your lordships, my lords, under 307. Because this person is my guard, he's there to protect me. I go to set up a plant, there's no role. Lordships examined that on 16/7 order.
Right, but we are only concerned with this delay.
But delay is not on our account, delay is on the account of the accused, my lords. They have filed an application in the High Court now again, after your lordships were pleased to direct that not direct or observe that that application was withdrawn. They filed it again, that state Every time they change their counsels, I can produce the order sheets before your lordships as far as the Gutsi talk matter is concerned, my lords. And lordships may see whether there's any delay on our part.
See this, we are not finding fault with you. Gutsi talk has to proceed. Gutsi talk may say take another 1 year or 2 years.
Yes, my lord.
Then the trial of this case will
Yes, my lord.
commence.
Yes.
By that time, though, he will complete.
6 months is the direction by your lordships in July.
Possible.
But provided that the accused persons don't keep filing applications, that's why I'm saying.
Can't find fault with this man.
No, I bow down, my lords, but.
Concerned with Gutsi talk.
My lords, I'll be.
The accused of Gutsi talk may be creating some problems.
It's a
2 years now.
It's a peculiar situation, but 2 years for a 307, my lords, it's a case under 307 where there were injuries caused. It's not a case for 307 without injury.
We know the matter. We have seen the photographs also of the injured person.
Yes, my lord.
But these are the hard facts. That's the problem.
Then allow me to file my reply, my lord. Let me place it on record then. To be heard on this. My state is not here.
You are not state.
I am for the complainant, my lord.
Issue notice.
Lordship, please.
Trustee, permitted. You serve the standing
Please, ma'am.
counsel.
We'll do that.
Put it on next to next Monday.
And
My lord,
permit
they
us
may
to-
waive, my lord.
We are waiving, my lords.
Please.
For us, not required, but a short counter, my lords, in a week's time, we'll file.
You may file it, no problem.
Lordship.
We are only concerned with the
I bow down. I understand. I'll place the delay part, my lords. Maybe a reiteration of your lordship's direction of the 16th July order, my lords, to the trial judge.
Won't make any difference.
Because of course it will, my lord, your lordship's court is, it'll make to the
This order is dated
16th.
2nd of September.
Just
Yes, my
consent
lord.
order.
On 2nd September,
Yes, my lords.
only 2 witnesses.
So now 4 have been examined out of 20. 4 have been examined out of 20. Therefore, the application by co-accused must stay.
We'll see.
Lordship, please.
Please.
They may have to implead us, otherwise they will, our counter, etc. Those technicalities are there, may not be accepted, or lordships may implead us.
We permit the learned counsel appearing for the complainant to file this counter.
Lordship, please.
Registry
Obliged.
may accept this.
I'm obliged.
Grateful.
Grateful.
Let's para 22 of the impugned order entirely proceeds on the basis that I did not deny receipt of this letter of 21st April. Now, this is completely contrary to the record. Completely contrary to the records. Your lordships will begin. I begin with the NCLT reply filed before the NCLT page 304.
No pre-existing dispute according to you?
Absolutely none. This letter is a fabricated letter, and this is right from the beginning my pleading, my lords. My pointed pleading.
There's no denial to that.
No, it's not correct, my lords. Page 304, if your lordship sees first, and then I'll come one by one. The NCLT goes on that basis of that pleading and holds I did not receive that letter.
What is the amount involved?
Well, amount is 2 crores plus.
No. 1 crore 10.
1 crore 10 lakhs. I'm so sorry, 1 crore.
Balbir Singh, should you not sit and resolve?
Balaji, just to give a little back. No, there is
Whether 9 is maintainable, not maintainable.
Balaji, I'll deposit in the court.
You also, it's a one-off mail, assuming it to be true. Before that, after that, don't say anything.
There's one more.
Credit notes not given to last para in that.
Two things. Just
Pointed denial minutes.
Just one.
I'm not finished, sir.
So only today
You are under the impression that the mail was not denied, but it appears.
It is pointedly denied.
It is
denied before the NCLT.
Brother suggested you should grab it.
No. The only thing which I'm saying today, the arbitrator has already been.
Well, this is the other problem.
Arbitration notice was issued, which was not disclosed in Section 9 petition.
No.
Which was prior to time.
No.
They appeared after this. The order of the arbitration they appeared in Section 11.
This is an independent remedy.
Issue notice.
Please,
what's your good name, sir?
Akash Nandolia.
Waive service of notice for and on behalf of the respondent. You file your counter.
Well, let us not proceed in the arbitration because this is something.
How can the arbitration be stopped today? They challenge the arbitration.
Very well. Let notice go. Let's
make it
very well.
In 2 weeks.
Very well.
Thanks, man.
Grateful.
Wait, please, madam. High Court, Malatanda. And it's on the very first day of listing of a PIL, my lords, the High Court takes it up, passes sweeping directions and disposes of the of the PIL on the very first day, filed at the instance, my lords, of a gentleman against whom, my lords, I have litigation pending. High Court records that. And then, my lords,
Demolition.
yes. But my lords, my instructions are, my lords, the objectionable part we have already removed, my lords, on 25th January 2025, my lords, after the High Court order, that we have removed it.
In this petition, you were not implicated as party respondent.
We were parties.
You appeared or not?
My lawyer appeared on the first day. First listing
My
and the only
lord
listing.
didn't appear. How do I? Huh?
Sorry, Mala?
You said my lord appeared, but how do I appear?
No, no.
In fact, my lord's direction is there in our direction. High Court should monitor the illegal buildings in Calcutta.
No, that is fine, but we have already removed that objectionable part. My writ petition pending before the High Court, my lords, has been rendered nugatory, my lords, by this order. High Court records, my lords, in the order, if your lordships have, my lords, at page 13, paragraph 19.
What is wrong with this judgment?
My lords, it's what is wrong is this, my lords.
Tell us.
Now, my lords, because of this order, my lords, all my licenses are, my lords, are gone. My conversion is gone, my lords. High Court has come out.
Everything illegal, sir. Every bit of it.
No, my lords.
This is Calcutta, na?
Calcutta, yes. My lords,
Now we are not going to say anything else because we have come down very heavily, and on the contrary, we have hailed the approach of the High Court that you must see to it that each and every unauthorized construction is brought down.
my lords, but High Court, my lords, we have already removed on 25th January, whatever, my lords, if your lordships have the page 16 direction, my lords,
No, we are not going to. intervene.
asking the municipality to proceed with.
This will dissuade the High Court.
My lords,
Next
my lords,
matter.
my lords, what I am saying is this.
No, sir. No.
The best left to the High Court.
No, next matter.
Lordship, I am appearing for Halishar Municipal Corporation.
It's all right.
My name may be recorded.
Okay.
May I say?
First, you bring down the structure, then your
already
name
done.
will come
It's
on
done.
record.
It's done on 25th of January.
Don't bring it down.
It's
this is
done.
Not record.
It's
इनका नाम मत लिखिएगा वो report करेगा.
Lordship, it's done on 25th of January.
The next matter.
May I say this, my lords? Let the High Court consider every other thing on merit, my lords.
It will
So far as we have already removed that objection.
Consider everything. Dismissed. Next matter.
Obliged, Lordship.
Please, Your Lordship. I appear on behalf of the petitioner. I am challenging the interim order of the Honorable High Court. Your Lordship, I will
50?
54.
54.
Lordship, I
What
will,
is this interim order?
Lordship, in the impugned order, the Honorable High Court has passed an order for the petitioner to deposit 50% of the decretal amount.
But this is a first appeal.
Please,
You
Your
have
Lordship.
preferred a first appeal.
Please, Your Lordship.
You have suffered a money decree.
Please, Your Lordship.
Order 41, Rule 5.
Please, Your Lordship.
How do you come out of that?
I'll confine my submissions to 4 brief grounds, Your Lordship.
Fine. What is the amount? What is the decretal amount?
It's 24 lakh 28,000
With interest? The principal?
with interest. The principal is 18 lakhs. With interest, it becomes 24 lakhs.
Fine. Your first appeal is of the year?
It's
2025?
2025. Yeah.
You don't want to make any deposit?
Your Lordship, please hear me.
Then the decree holder will proceed with the execution of the decree. Today, we are not going into the merits of your appeal. It's a money decree. Unless you show something very gross, that you should be absolved of this deposit,
Your Lordship,
your appeal is heard.
we are not against depositing, but we are against depositing 50% of the entire decreed amount.
Then how much would you deposit?
Please, Your Lordship. Lordship, this was also raised before the learned trial court. Out of the 3 respondents, the 3 plaintiffs who filed the suit before the learned trial court, only one came to give evidence and came in the witness box to prove his claims. The other 2 plaintiffs never came in the witness box, and the claims, as far as those 2 plaintiffs is concerned, is not proved.
1 second.
It is a
Now you have been ordered to deposit 50%.
So around 12 lakhs, which you don't want to deposit. You don't want to deposit.
I want to deposit even if for the sake of argument, if I want to deposit only 50% of one of the petitioner shares. Your Lordship, there were 3 separate transactions of 6 lakh rupees, alleged separate transactions by each of the plaintiffs in this respondents herein. And only one of the plaintiffs came in the high court, in the trial court to prove his claim. The other 2 plaintiffs did not come to depose.
Is it a company or some partner
Individual.
firm or something?
No, Your Lordship.
Then how 3 individuals with 3 separate independent transactions preferred one particular suit?
They are real brothers, Your Lordship.
You deposit 50% on withdrawal.
Your Lordship,
You deposit 50%. When time comes for the decree holder to withdraw it, we'll tell him to furnish some tangible security.
Your Lordship, then please allow the petitioner to submit bank guarantee, bank security, because Your Lordship, there is a history of litigation.
Also, you have to deposit back-to-back amount. You don't get bank guarantee without a back-to-back deposit.
Your Lordship, there is a history of litigations, and Your Lordship, the respondents are elderly citizens.
You have to deposit this amount with the court. After you deposit, the other side will say, now permit us to withdraw.
It's already permitted in this order.
Your Lordship, there is one more submission that this 50% includes the interest amount.
Amount may be dispersed to the respondents in the manner and proportion as contemplated in the imputation.
The undertaking only. Maybe 50% of that we can secure. Or we can secure the whole thing. That we can secure.
Your Lordship, also there is Order 41 Rule 5 does not provide for interest, Your Lordship. 50% as ordered by the High Court includes the interest, Your Lordship. So 50% of the principal amount that to confine to one of the plaintiffs is my humble request, Your Lordship.
You have to deposit, sir.
And then 6 months may be granted, Your Lordship, to the petitioner to deposit.
You made this request before the High Court.
And some security for release.
The petitioner is the original defendant. He has suffered a money decree. The judgment and decree passed by the trial court is now a subject matter of challenge before the High Court of Rajasthan by way of first appeal number 295 of 2025. The High Court has directed the petitioner herein to deposit an amount, to deposit 50% of the decreed amount, and subject to such deposit, the judgment and decree, money decree passed by the trial court would remain stayed from its operation, implementation, and execution. The High Court has also observed that once the amount is deposited, the same shall be disbursed to the decree holder, original plaintiffs. We do not find any error, much less any error of law in the impugned order. However, the learned counsel fervently made an appeal before us that some time may be granted to deposit the 50% of the decreed amount. We are of the view that this request may be made before the High Court by way of a separate application. If any such application is filed, praying for some time to deposit, High Court may consider it appropriate. With the aforesaid, this petition stands.
Your Lordship, please allow, if they withdraw it, a security may be provided. A bank's.
First, you have to deposit it, right? After you deposit, then the stage will come for them to withdraw that amount.
It's ordered in this order.
It is ordered, Your Lordship, that they will withdraw.
We also take notice of the fact that the High Court has permitted the decree holder, original plaintiffs, to withdraw the 50% amount that the judgment debtor would deposit as contemplated in the impugned judgment and decree, with the undertaking that if the judgment debtor succeeds in appeal, the plaintiffs would refund the same along with interest in accordance with law. Good point. We do not approve this. The High Court should have asked, or rather directed, the decree holder, original plaintiffs, to furnish some tangible security in the form of bank guarantee, etc., and not just asking for an undertaking. This aspect shall be kept in mind by the High Court while deciding the application which the petitioner herein may file, praying for time to deposit the amount. Next matter.
Much obliged.
May it please, my lord.
But supposing if you do not prefer this application, if you decide that I don't want to deposit, then how will the later part of our order come into operation?
In the event of.
Order will revert.
We make it clear that if no such application is filed by the petitioner herein within a period of 2 weeks from today, then this order shall lapse. Our order shall lapse. Next.
Much obliged. Much obliged.
You thought of it. It's been limbo.
54.
Yes, Mr. Chaudhary.
55, my lord.
55.
55.
55. This had come to be mentioned, my lord. It is regarding the transfer of the elephant from the petitioner's temple to respondent number 6. My lord, may I just indicate, since I had mentioned it on behalf of the state, what had happened after the order was the order has been complied. But there was great unrest in the area of Kolhapur, my lord, since a lot of religious sentiments were attached. A meeting was convened. Now, my lord, there seems to be an agreement where respondent number 6 proposed to open up a center at Kolhapur. They have identified a land jointly.
Who are you?
My lord, I appear for the state, my lord, because it reached the state government and we had to mediate.
For MA? Show us the MA.
No, there's a. No, there is no.
You were the original petitioner, Mr. Chaudhary?
Yes, ma'am. I was the.
The judgment of the Bombay High Court.
Yes, ma'am. Against the judgment of the High Court.
So now, why this MA is filed?
No, my lord. Well,
Where is your MA?
no, my lord, we have not filed any MA. Your lordships had directed that the matter be listed again for compliance.
That the last order records was to be listed for compliance. That's.
Get the MA, only one office report is there with MA.
Yes.
Now, what 15 times we were going around this computer.
No, my lord, there is no MA. We have.
There is no MA, my lord, since
My
it
lord,
was.
only
We will record the compliance.
just the liberty to go back to the high power committee so that the matter can.
Now,
some sort of
briefly, I can tell what the issue is. My lords had directed, the High Court said, please transfer this elephant from a particular Kolhapur place.
Why are you harassing this poor animal?
No, my lords, I'm the trust. I have no problem. I'm in Vantara, which is managing. It seems the state is facing an issue, which is the unrest, the social unrest in the state, in the city of Kolhapur because of this temple belongs to a particular community where this elephant was there, my lords. Now the state, the position is.
But the condition of the elephant was very bad.
Very bad, Malasi. So what after that we were called, Malasi.
Suffered injuries.
Yes, Malasi. Yes.
Veterinaries examined.
Yes. Your lordship is absolutely right.
Yes. Is not well.
Yes.
In such circumstances, the decision was.
Absolutely. The decision has been complied. Subsequent development. So as a trust, Malasi, what we were called by the state, we have identified 7 acres of a plot. We will create a facility in the state of Kolhapur and a city of Kolhapur where we will provide the facility of doctors and the other facilities which are available. It's only on the request of the state because the state has faced this issue, which is a law order situation in the city of Kolhapur, my lords. Subject to my lords permitting, they going to the high power committee. And if the high power committee is satisfied with whatever the proposal is to be given by this particular trust and the state agreeing to it, that's the only purpose for which the today in a compliance, because the order was listed only for compliance.
Why are you nodding your head like that?
I was appearing for the original complainant, Peter, on whose complaint the elephant came to be transferred. My only submission to your lordship was, your lordship has rightly pointed out, there is no MA. If there are subsequent developments, there is no facility also. They're now proposing that they will establish a new facility to which they will transfer the animal. Those are not things that your lordship should be concerned with because there is nothing in pleading. There is no basis on which to take cognizance of these developments. Without an MA, they are seeking to reopen your lordship's order.
Don't go to the committee then. Data can also be.
We'll send you all to the high-powered committee.
Yes.
You also make your submissions. Mr. Balbir Singh, you also make
Please,
your
Manoj, yes.
submissions. You also.
Yes.
And
you also.
we'll also.
What is this high-power committee?
So, my lord, this high power committee was originally constituted under an order of this honorable court to look into transfers of these scheduled animals. And my lord, that committee has been continuing ever since.
Who is heading it, Mr. Madhukar?
Yes, my lord. Justice Deepak Gupta is heading.
Right, Judge, that's Deepak Verma.
Deepak Verma.
That's
Deepak Verma. My mistake. I apologize.
Initially, the Tripura High Court ordered to set up that committee,
This,
confirmed by the.
this matter has come up before us for reporting compliance. Our order dated 28th of July 2025 reads thus. Good. We are informed by the learned counsel appearing for the parties that the elephant was shifted from
Kolhapur.
to
Jamnagar.
Jamnagar. The elephant as on date is in Jamnagar.
Yes.
A request has been made on behalf of the state of Maharashtra that in the wake of the transfer of the elephant, public sentiments have been hurt. In such circumstances, the parties have reached to a consensus that the entire issue be looked into by the high power committee constituted by this court.
Please, Manoj.
In
No, it was constituted by the
Where?
Honorable Tripura.
No, where is it?
Confirmed by
Confirmed by this court. Where is it? But by the High Court, the Tripura High Court order dated.
एक मिनट by क्या लिखा आपने?
7
वो सब जाने दो consensus वाला पढ़िए. By a high power, it is called high power.
High power.
Powered committee.
Please, Manoj.
It is powered.
Powered, Manoj.
High powered committee.
Please, Manoj.
Headed by, chaired by,
Retired judge.
chaired by a former judge of this court.
Yes.
We are informed that this high-powered committee was directed to be constituted by the Tripura High Court
Yes. By the order dated 7th November 2022, Manoj.
in passed in writ petition civil
number 17 of 2022, titled as Sudipta Nath versus Union of India. I just passed.
just right in all given.
That's at page 11.
This order of the Tripura High Court ultimately came to be affirmed
Yes,
by this.
this court. I'll give the details. Manoj.
With the order dated so and so, passed in so and so.
That's at page 39.
Let the parties appear before the high-powered committee
Please, Manoj.
and the issues be resolved accordingly.
Deeply obliged. Great. Just keep it.
May I make one request, Your Lord? There is a change in circumstance. If there is no change in circumstance.
Likhiye, it is needless to clarify that the high-powered committee shall hear all the stakeholders,
Very well.
including the original
Complaint.
complainant, the
Peter,
writ petitioner before the High Court.
the complainant before the High Power.
Hey, you were the writ petitioner, na?
Not
No, I was the writ petitioner. High power committee
May I
passed an
clarify?
order against us. We filed a writ petition. They were the
All stakeholders.
Original complaint
Yes,
before the High Court.
Original complainant before the high-powered committee.
Yes.
Great.
let
Deeply
it be
obliged.
decided without getting influenced by the observation made by the High Court, because it's
This court's on this time.
Well,
No.
since the parties have decided to go before the high-powered committee and get the issues resolved, the high-powered committee may take an appropriate decision without being influenced by the original judgment of the.
yes, I'm so.
they are only saying that there is a subsequent development.
My friend is just a
New facility. If there is.
You go before the high-powered.
Very well, Manoj.
I'm so.
This is too much, sorry to say. And state of Maharashtra if you will keep succumbing to public sentiments against judicial orders, there will be no rule of law tomorrow.
No, my lord. May I clarify?
Once there is a judgment of
I
the
quite
High
see.
Court, matter travels to the Supreme Court, it is affirmed as a state, it is your duty.
We did
See
that,
to
my
it
lord.
that
We did that. We did everything, my lord.
Very
But,
dangerous. Very dangerous.
my lord, may I only indicate the scale of this?
You can't bring public sentiment.
No, my lord. May I only indicate the scale of this, my
To
lord?
abide by the law.
My lord, I quite see that, my lord, and we tried everything.
Next matter.
Grateful.
Please, my lord. My lord, this petition is arising out of the same common judgment, my lord, which is impugned in item 56, my lord. That CPS college, that diploma college. Yes, yes.
Oh, that Mr. Singh's
Yes, yes.
matter.
Yes, my lord.
Mr. Singh's
Yes,
matter.
yes, yes. My lord, this matter may be tagged with this.
Your lordship said.
When should we fix the hearing now?
Lord, only one small request, Lord, your lordship has
Now
asked.
there is no problem. The bench will continue.
Very good. Lord, there is only one small request I want to make, Lord. This is an institution only for the interim order. If your lordship permit me only 5 minutes. This is an institution functioning since 1912, recognized in the 1916 Medical Degrees Act, recognized in the 1933 MCI Act, recognized in the 56 MCI Act, and even the current act says, Lord, that the savings and Lord accepts this. From Lord 56 to 92, if your lordship will just recall the Indian Medical Council Act regime, from 56 to 92, there was no bar on anybody setting up Lord or starting a new course. That is why 10A, 10B, 10C were inserted. Your lordship will recall that. Now 10A, 10B, 10C were inserted and it said everybody will have to go to the MCI for the purpose of starting a new course. 2000, the PG regulation came. The PG regulation said that anybody granting, and just have one page only, anybody granting a postgraduate degree prior to 93, that is prior to the amendment, will be permitted to grant more degrees. Just have a look at that one document only, Lord, and I am only saying, Lord, that these are students who have been admitted when admittedly it was a recognized course.
Continued, na?
They have continued, but they can't take the exam. They can't take the exam.
No, the reason.
So, your lordship, I am not saying, one second, I am not saying, Lord, give me any relief. I am for the institution. I am only, there are.
Ordinarily, the exams would be taken in which month?
My lord, I have to hold the examination, Lord. I have to hold the examination.
23, 24?
Because all these students, Lord, it's no fault of theirs. Whatever our legal position, it is not the fault of theirs. So at least their exam can be conducted. Your lordship may even make that subject to outcome. But at least, Lord, because the Attorney General, obviously, Lord, it will appear, he'll also take some time.
What happened
It can't
here is,
be.
Milord, there is a.
The problem is this.
Who are you, Mr. Chaudhary?
Milord, I am the PIL petitioner. I was the PIL petitioner.
How are you concerned with this?
Milord, my petition got allowed, Milord, and it is
How
found
are
that
you
they were
concerned
illegal.
with these colleges?
No, Milord, Milord,
That is highly questionable, but I don't want to get it.
How did you conceive the idea of
Milord,
preferring?
I am the
PIL?
erstwhile president of Maharashtra Medical Council. And Milord, I found everything which was being done by them was illegal. The colleges, institutions were run without seeking proper permission.
Wait a minute.
Yes.
Milord,
MBBS.
We need to hear this matter and
Yes.
then
Yes.
we'll take an appropriate.
Yes.
one. What do you propose to do with the students?
Now, Milord, that's what.
Supposing if we dismiss this petition and affirm the judgment of
Yes.
the High Court, Bombay High Court, that's the end of it.
No, still your lordship will protect the student. Lordship have done that.
let me-
But protection of students,
In any case, we'll have to.
which academic year?
Milord, let me.
Which academic year?
22.
Milord, I'm appearing for NMC, Milord. On the last day, Milord had to issue notice to the Attorney General, Milord.
That's
Milord,
the
we have
reason why it is
conveyed
kept-
him, Milord. He may be joining online also because he's.
Yeah, I've already joined.
Milord,
Your lordship
government
had-
will have to take a call, Milord. The reason is, Milord, the course was discontinued in the year 2009, Milord. Then again in 17 for few subjects, it was started for 5 colleges. What mischief they have done is, Milord, they had en masse allowed private hospitals to conduct the course. They are not an examining body.
Not government hospitals, not private.
5.
What were you all doing?
I beg your pardon, my lord.
Let's start with once again.
My lord, we continuously, that's why we de-recognized it. We continuously de-recognize them, my lord. Then they manage from the state, where the state has no power, my lords. My lord, in this, what I'm suggesting is, my lords, let government take a final call on it, this, my lord, because these colleges or these students are not legally admitted.
Government means union? Union?
Yes,
Union of India.
Union of India. my lord.
That's the reason why your lordship asked the Attorney General.
I've logged in.
We were sent by the governments of Maharashtra and Gujarat.
That
We were sent to the,
5 colleges.
no, we were sent to
Granted.
various government
Apart
hospitals.
from that, my lord, this
That's the real problem.
society has managed themselves, my lords.
But allow the Attorney General to
Please, my
speak
lords.
something now.
Please, my lords, he may be in our favor.
Mr. Attorney General, we are waiting for you to say
No,
something.
I didn't want to interrupt. I didn't want to interrupt the flow of other counsel's argument. Now, today, the only question is to whether the students who have already enrolled, if their fate has to be taken care of and addressed, without going into the larger questions. I had a discussion. Probably, if you are going on that direction, give me about 2 to 3 weeks time to find out which is the best modality, so that we don't skip again. So give about 2 to 3 weeks time, find out what can be done, because it's a question of holding an examination in a proper way. It is not.
Have the matter itself, Lord. Otherwise, Lord, don't keep the whole thing in limbo.
As far as the merits of the matter is
My
concerned,
friend is not agreeing for an interim order today. Then, if after 2 weeks, whatever your lordship said is.
This can be recorded, Mr. Singh, that they are contemplating mechanisms to regularize. the
Exactly.
dignity of students.
Only for the purpose of
Yes, why not? Why not? That can be recorded.
Only for the purpose of holding the examinations.
The learned Attorney General is able to persuade the government
Well, that's
to work out some modality.
Yes, Lord. That will be
Our own interest.
Yes, absolutely. At least of the students. I will still be wanting Lord an early decision, but at least for the students, Lord, it will be.
Of course, the persuasive power of the Attorney General need not be doubted.
Pardon?
I said the persuasive power of the AG need not be doubted.
Don't doubt at all. You have all the power and the might.
He's the Attorney General for India.
Yes, for it. Due to paucity of time, we are unable to start with the hearing of this matter. We are conscious of the fact that this litigation has something to do with future of hundreds of students. Good point. Today, the only concern is about the examination to be conducted by the colleges concerned.
No, by the petitioner. Lord. We can't.
By
We
the
are an
petitioner,
examining
Lord.
body only.
By the
Really an examining body.
The College of Physicians and Surgeons.
Examining body.
By the examining body.
The institution, Lord.
The institution,
I'm
the College of Physicians.
By
The
the college of,
institution will not do it.
by the
will not.
institution, namely the College of Physician and Surgeon, right?
That's right.
We requested Mr. Venkatramani, the learned Attorney General for India, to intervene and assist this court in this litigation. Learned Attorney General would submit that he would speak to the authorities concerned and try to work out the modalities so as to protect the interest of the students who have already been admitted and are
Awaiting exam.
awaiting conduct of the examination. The learned Attorney General prays for 3 weeks' time to come back.
Lord,
with
it said
some-
2 or 3. Could you Lord give
I said, let it be 3 weeks' time.
3 weeks' time. 3 weeks' time. क्या लिखा आपने? 3 weeks' time to come back with some arrangement by which the interest of the students can be protected. But we have yet to hear the matter on its own merits. In other words, we have yet to look into the impugned judgment rendered by the High Court in public interest. However, our first endeavor should be to see that the students are not left in lurch in this particular fight between the college, original petitioner, and the government. We request the learned Attorney General to work out something and come back to us after 3 weeks. By any chance, if some viable solution is not brought around, we shall proceed to hear the entire matter on its own merits.
Very deeply obliged.
Okay, sir, Mr. Attorney?
Absolutely not. Absolutely not.
Okay.
Some date immediately after 3 weeks.
Should we keep it on 3rd October is a holiday?
3rd is a holiday. Lord.
It's a
That whole
holiday.
week.
Yeah.
Then we could put it on any NMD day.
It could be.
7th of October. Tuesday.
7th is already.
Huh?
Tuesday.
7th of October.
Top of the board, Lord.
Top.
Deeply obliged.
Could it be on 8th if your lordships will not find it difficult? 8th.
Deeply obliged.
Grateful.
My lord,
Grateful
item
to Lord.
57 may be tagged with this 56 minutes.
No, we dismiss it.
No, my lord.
Dismiss it.
No, no.
Okay.
Grateful. My lord, 56 days delay is there.
How much?
56 days.
56 serial number and 56 days.
Yes, tallied it.
Okay, chalo, delay conduct.
Grateful, my lord.
It's an entry tax matter.
Entry tax.
Tax.
But you want. Yeah, we can.
We'll sit up to 1 o'clock. Call. Any matter, we can take it up and finish it up. Any matter, any fair available.
I appear in the entry tax group. We want to withdraw a matter in that. That is
For usual order, because he must have availed the benefit of that scheme.
amnesty scheme. It's 301.170. The item number is 301.
Sasram, that is a different bench. That quorum is in the afternoon.
No, I was told the bench is not sitting or is continuing at 2, Your Lordship. I'll mention at 2 o'clock again.
301 wali.
2 p.m. That's at 2 p.m. with-
Your Lordship, I'll mention at 2. I was told it was not. Apologies, Your Lordship. Apologies.
My lords, I'm appearing for respondent number 2 to 4.
Well, as your lordships asked a question, there are some longish matters which your lordship may adjourn subject to item 40 was for final disposal anyway, since your lordship is rising. Otherwise, I leave it to my lords, we are ready. Item
No,
40.
We'll be able to sit maximum up to 1 o'clock.
That's what I heard, Mulu. That's why I intervened, because the lordship said so. I don't
Keep
think.
it on some other date.
Lordship, please.
Any urgency in the matter?
No, but this is a final hearing on an issue of law. Just 5 seconds, brother, about whether establishment means protected workmen per unit, per branch, or for the whole establishment as a whole. It's an IDM. It's a legal issue to be decided.
We'll give you some date. We'll give you.
Lordship may indicate some date. Very good.
Proceed.
My lords, I'm appearing for respondent number 2 to 4. I'm seeking some time to file reply, my lords.
In 32.
Yes.
32, my lord. Service is complete, my lord.
Adjourn.
May I please, my lord.
Lordship, in item number 33, I am humbly seeking interim bail, my lord, because already I have underwent 45 years. And my lord, I am 68 years old man.
Wait a minute.
Please, my lord.
We have already issued notice in this matter.
Yes, my lord.
We observed something last time now.
Please, my lord.
What is the date of that order? What is the date of? While you were on parole, you committed one another murder.
But at the age of 28, my lord. Thereafter,
Age is not relevant. You are now not entitled to seek any remission.
no, I am entitled to seek remission, my lord. Thereafter, I received about 10 years remission, my lord. That is what the custody certificate says. Even thereafter, my lord, I was enlarged on parole, and there are no other offences alleged against me thereafter, my lord.
You may be out of touch with your skill also.
Totally now I am reformed, my lord. Kindly appreciate. Page number 40, the advisory board has already recommended.
You have invoked Article 32
Please, my
for
lord.
us.
Please.
And in this petition, you are now seeking for bail.
Yes, my lord. This honor, please.
In connection with the first offense,
Please, my lord.
you were convicted and sentenced to undergo life imprisonment.
Please, my lord.
Did you prefer any appeal in the High Court?
Yes, my lord.
Dismissed?
Yes, my lord.
You didn't come to the Supreme Court.
No, my lord.
Then you committed second offense. Trial court has held you guilty.
Please, my lord.
Sentenced to life imprisonment.
Please, my lord.
Have you preferred any appeal in the High Court?
That is dismissed, my lord.
So you have not challenged both the judgments.
No, my lord.
In such a scenario, how do we release you on bail in this petition?
Lordship, in that liquor tragedy case, in very infamous liquor tragedy Kerala,
If your conviction has attained finality,
huh,
and if we release you on bail,
this honorable court, my lord, let me explain it. This honorable court, in a similar petition, in that case, my lord, 31 persons were died.
this man is in custody past 45 years.
35 actual sentence and 11 years.
So what is the stance of the state here in this case? What have you to say?
What is the,
What is the policy?
20 years, my lord.
as far as the conduct of the person is concerned, I got a certificate that he is.
Are you ready to consider his plea for remission? We
Your
record
Lordship
it.
may direct the authorities to consider again. That will be better.
Lordship, already,
The applicable policy.
my lord, already
As per-
there is a direction from the honorable high court. They did not consider it. Page number 41.
Keep it pending. Our order dated 22nd of August 2025 reads thus. In pursuance of our aforesaid order, Mr.
Nishya Rajan Shankar.
Learned Counsel, Mr. So-and-so, the Learned Counsel has appeared on behalf of the state of
Kerala.
Kerala. Full point. Next. The Learned Counsel appearing for the petitioner submitted that his client is in jail past almost 45 years. According to the Learned Counsel appearing for the state, the petitioner could be said to be undergoing sentence past 35 years. Full point. Be that as it may, we are of the view that the petitioner should immediately prefer an appropriate representation addressed to the competent authority of the state government and pray for remission of the sentence. Full point. We grant 2 weeks' time to prefer such representation.
Already preferred, my lord, as per the direction of the high court. That is page number 41. They did not release me. That is why I am before this honorable
They
court.
have taken some decision on that representation.
My lord, no decision. That is written in my writ.
Not been communicated with any decision.
No, my lord.
Where is
Many,
that representation?
kindly see page number 41, my lord.
Annexure?
Page number 41, that is high court judgment, my lord, annexure P1.
The item number
Many applications I have filed.
20.
Page number 41, my lord. Many applications I have filed as per the
The last one. The last in point of time.
Your lordship, that is immediately, immediately after delivery. Please.
Any difficulty in referring to them, you are there advising, and with our order, file it will have a.
Then lordship, I will do, kindly keep my repetition pending here. Otherwise, they will dismiss it.
Full point. We grant 2 weeks' time to the petitioner to prefer an appropriate representation. Full point. Once the representation is received by the state government, the same shall be looked into immediately, and an appropriate decision shall be taken within a period of 4 weeks thereof. And place the appropriate report or decision in that regard before us. Good point. Right? Okay. So 2 weeks and 1 week, 4 weeks. Post this matter once again after 8 weeks. The learned counsel appearing for the state of Kerala shall inform about this order to his client and shall also see to it that the appropriate decision is taken on the representation that may be filed by the petitioner.
Oblige.
Please, Your Lordship. In 34 matter, the application for remission has been accepted. He will be released within a short time, Your Lordship.
Likho. The learned counsel, sorry, 1 minute. Your appeal is dismissed by the High Court.
I'm for the state, Your Lordship.
My appeal was dismissed and confirmed by the notice matter, my lords.
The appeal SLP.
Petitioner has already undergone the custody.
SLP is also dismissed.
No, my lord, this is pending. This is SLP against the conviction order, confirm order.
Okay. You have already taken a
It
decision.
is taken a decision on 22nd of August, 2025.
But leave is not granted.
Not my lords.
This petition arises from the judgment and order passed by the High Court of Judicature at Allahabad, dated 10th of January 2018, in jail appeal number 3824 of 2017, by which the appeal preferred by the petitioner herein against the judgment and order of conviction passed by the trial court came to be dismissed. Good point. He is undergoing sentence for
Approaching 17 years, my lords.
We are informed that the petitioner is undergoing life imprisonment past 17 years. Full point. Mr.
Garvesh Kabra.
The learned counsel appearing for the state has instructions to make a statement that the government has decided to remit the sentence. Within a short period of time, appropriate orders would be passed and the petitioner would be released from jail. Let this exercise be completed within a period of 4 weeks from today. Okay, the petition stands disposed of accordingly.
Lordship, one just line that if he is not wanted in any other case.
Yes.
Goes without saying. Next matter.
Yes.
Much obliged, my lord. Great. I'm great.
I'm seeking a pass for my lords.
Janet.
My lords, in item 35, my lords, I'm being led by Mr. Srinath Sridevan, my lords, from Chennai High Court. He's in another matter, my lords. Could your lordship kindly have it next week, my lords? Next Thursday or Friday, subject to your lordship's convenience.
35. We have already adjourned 35.
You've passed it over, my lords.
Jen.
Oh, I'm sorry.
She wanted Passover.
Oh, very well, my lords. Could your lordships have it next Thursday, my lord, subject to your lordship's convenience? Very well, my lords.
Yes.
May it please the Lordship. My lord, against a concurrent finding of facts by trial court and first appellate court,
Correct.
the second appellate court overturned the judgment, my lord.
Who are you? Plaintiff.
I am for the plaintiff.
What was your suit about?
Suit for specific performance of contract. It was decreed. It was decreed by the trust.
Specific performance. Agreement of which year?
Agreement is 2001. But one thing is, after this judgment passed by the High Court, we preferred an appeal and you also issued notice. And he appeared in caveat. By the time the caveat, he did not bring it to your lordship's notice. When he appeared, he has disposed of the suit property. He had no substituting title.
Purchaser has and
The purchaser are not before your lordships.
okay. Relax.
You can always be asked to convey again. There are judgments of this court of
My
similar.
lord, my lord.
Wanted to
They
get
can't run
rid
a
of
race to
you.
this court.
My
He
lord, my
wanted to get rid of you, so he has sold it off.
lord.
What else can
Keep those judgments where if you succeed,
2001 is the date of the agreement.
Agreement, my lord.
What is the sale consideration?
Sale consideration is 2 lakhs.
Why should we go into it now? Since you are bringing it to our notice, we should implement the subsequent.
unless we find merit in it.
Okay. 2001 is the agreement.
Agreement, my lord.
What is the sale consideration?
Sale consideration 2 lakhs, we paid 1.5 lakhs.
By what time the sale deed was to be executed?
My lord, the sale deed was to, because by that time it was to be executed within 3 years.
3 years.
The reason is
Your suit came to be allowed.
allowed,
First appeal came to be dismissed.
dismissed. No,
Now, what weight will the High Court in second appeal in reversing the decree of
my lord,
specific performance?
second appellate court said it was that way by mortgage.
Achha.
But it was not a mortgage, it was a consistent case of the plaintiff that it was a specific purpose contract, it was an agreement for sale. They took the plea.
What is this, land?
Land is a small dilapidated house.
House.
They are husband and wife, they are no more. They died issueless, and the present respondent is, he claims to be adopted son. And after he came to the picture added as a party.
Come to para 40 of the impugned judgment, sir. Come to para 40.
Admitted loan.
Come to para 40.
Whenever huge consideration is given and something is left, if you can start with the presumption that it is a loan. Just read 40.
Come to para 40.
Para 40.
It is admitted that the defendant has received.
Since it is admitted the defendant has received a sum of rupees 1,50,000 by way of loan, it is not a loan, my lord. It is his case is there.
Sir,
I am reading out.
please read it as it
My lord.
is.
From the respondent plaintiff under Exhibit A1, the appellant is directed to repay the entire amount of 1,50,000, though it is stated that the defendant had paid some amount by way of interest. This court is unable to deduct any amount paid by way of interest.
So he has to pay you 1,50,000 at the rate of 12% interest, right? Now
Right.
come straight to para 38. That should clinch the issue. Come straight to para 38.
Good. The suit property is an extent of 2 cents of land within the municipal limits of Velo town. More than the value of the building, the value of the land would be high. This court also accepts the plea that the sale price mentioned in Exhibit A1 is far below the market value as on the date of sale agreement.
Correct appreciation. by
My
the
lord,
man.
there was no evidence.
Next matter.
My lord, there was no evidence at all.
Next matter.
My lord, there was no evidence.
No, sir.
My lord, I will argue on this case on merit.
Court should not deprive somebody.
My lord, I will argue this case on merit.
1,50,000. Have you paid him back?
No, my lord.
We have deposited it.
Deposited? Okay.
My lord.
fine. Next matter. 38.
My lord, your lordship should have heard the matter on merit.
No, sir. Thank you.
37.
Huh?
We were not
I
there.
mentioned in the morning because
We were not there. That's all right, Lord. I was just asking if I have some difficulty. Lordships have kept it on Tuesday. Can we have it on 7th?
Okay, 7th.
seventh, same top of the wood.
Right, top of the
DP of line.
Like 38.
Multiple respondents are not involved or they are not able to. Bar also has absolutely.
You know the better.
She's born good faith.
Everything is on good faith. Less said the better. Who appears in 38?
Well, some for the petitioner, my lord.
Yes,
Notice
what
was
is
issued for the
topic?
limited purpose of mediation, my lord.
Mediation?
Please, my lord.
My lords,
Reverend
I am
Assistant.
appearing for the respondent. My lord, my instructions are that though notice was issued on 17th February, no offer at all has been presented by the petitioner side. In fact, my
My lord,
instructing
my
counsel reached
instruction
out.
is the president of the Sangam has been admitted in the hospital. They have tried with him. They have said, may I request, my lords, maybe refer to the mediation center.
One last
My
opportunity.
lords, may I please request, my lords?
You
Can it
talk
be,
to the other side.
please, my lords, can it be referred to the Supreme Court Mediation Center, my lords? In that way, both the
Okay,
parties will.
chalo, inko Supreme Court Mediation Center, which one?
Oh, bless
Very
you.
well, my lords.
There's a letter.
Yes, my lords. Please, my lords. I'm for the petitioner. Lords, while issuing notice, my lords were pleased to observe.
You have circulated the letter?
No, my lords. No, not the other side has circulated the letter. So while issuing notice, my lords were pleased to, my lord, observe that if this matter can be settled by us paying some reasonable amount, because lords really in that sense have today paid.
Have you all talked or not?
Lords, in the reply, they say that they're not willing to really offer anything. But lords, in fact, we are willing to offer some reasonable, my lord.
Would you all like to go before the Supreme Court Mediation Center?
We can try that.
Huh?
Yes. I mean, the connected, we can try that.
Send them to the trial,
My lord.
failing which will hear it out.
Lordships, please. Lordships, please.
Next match.
My lords, I am obliged.
Who have 40, Mr. Dr. Singhvi was there. 40 we prayed for.
We adjourned it.
We have adjourned it. Next matter.
Your Lordship, this is an appeal filed by the father after this Honorable Court exercised its powers under 142, closing, one, dissolving the marriage, two, closing the criminal matters between the parties, and leaving the aspect of guardianship to be decided by the family court, by the guardianship court. The matter thereafter and the aspect to be decided before the family court is one aspect. There was a counselor report, expert report that was called for by the High Court when the mother made an allegation that the father had shown the daughter during one visitation an objectionable photograph. No details of what this objectionable photograph is. Thereafter, the daughter told the mother on the very same day of this visitation. The mother sends the daughter for visitation the next time, and this allegation is thereafter made at the fag end of trial when the family court is to pronounce judgment after trial.
Your application was partly allowed.
My application is partly allowed. Today,
You put an application under Order 18, Rule 70
Yes.
for further cross-examination.
Yes, sir.
And in what manner it came to be partly allowed?
Sir, it came to be allowed to the extent that the father can lead evidence in order to establish a good relationship with the child, and he can produce any other witnesses to that effect. It came to be dismissed on the aspect of cross-examining of these experts who gave the expert report.
What type of expert report?
It was a child psychiatrist.
You want to cross-examine the psychiatrist?
Sir,
Why? For what?
if your lordship has the reports, the two reports that are there, they are in themselves deciding the matter. Experts were appointed under section 12.
And the litigation is at what stage now?
The trial after trial and a judgment that came from the family court in the guardianship matter, the matter was remanded to consider the aspect of the findings of this expert report. The trial in that has commenced. It is a time-bound trial to be finished.
Now, in that proceedings, you moved this application
No,
under
sir.
Order 18.
Yes, sir, in those proceedings.
That is too much.
Your lordship may see just on section 12 of the Family Courts Act.
You can cross-examine any other witness as permitted by the High Court. But to summon those psychiatrists,
If your lordship just notices, if this were, because the nature of allegation that is made is
what is
akin,
the age of the child?
she's 15.
Why are you all harassing her?
Your Lordship, she had a perfect relationship with me. In fact, in October of 2022, a court-appointed commissioner looks at the visitation, conducts the visitation and says the child has a good relationship with the father. 1 month later, this allegation is made and my access is thereafter stopped. 1 month later, that I have shown objectionable photos. There are photographs of happy times of this visitation of 20th of November 2022. The mother then volunteers the daughter, if the father has shown the daughter such objectionable photos and has not cared for the welfare, the visitation is given on the 3rd of December.
What is the gross error in this order passed by the High Court? According to you, what is that error which warrants interference at our instance in exercise of our jurisdiction under
If your Lordship has section 12, if your Lordship has section 12 of the Family Courts Act first, for a moment.
First thing, ma'am.
Sir.
Order 18, Rule 17 has nothing to do with the litigant. It is the power of the court. If the court wants some clarification, it can invoke Order 18, Rule 17 and summon a witness for the purpose of clarification. You cannot, as a party to the litigation, invoke Order 18, Rule 17.
If your Lordship has,
Well,
if your Lordship would have the Family Courts Act for a moment. It is only because under the POCSO Act, if your Lordship would to consider.
Now proceed with whatever High Court has permitted you to do and don't harass this poor girl. Next time.
Yes, Your Lordship, may I please submit? I am the respondent, Mother. Sir, I have moved an application under section 142 in some very abject circumstances. If Your Lordship may kindly see.
What are you seeking? What?
I am seeking, because of their gross misconduct, Your Lordship had considered our case and previously and passed an order considering those reports. What had happened is that the child is now going to turn 16 and this litigation is pending since 2012.
Your daughter is with you now.
Yes, sir. And they are not letting the litigation to end at all. It will continue for the next 2 years. On every week, there is one application or the other which they file in Honorable High Court or the Family Court.
What do you want us to do?
That to dismiss their case, sir, because it is no longer running on merits. It is running only on vindication. And
Case which is pending where?
in the guardianship petition in Saket Court. Your Lordship, let me just tell you one thing.
In exercise of our jurisdiction under 142?
Yes, sir.
Why should we do that?
Because I will tell you, sir. I will tell you, sir, that the misconduct was that he had taken the child to a COVID containment zone. The child contracted COVID. I lost my father. I was on deathbed. And then later on.
Close it, everything closed. Come on, next man.
Sir, please then at least let it be time bound. It is going to go endlessly.
He is before us. You are the respondent. Next man.
Sir, but I moved an application, please.
Make a request to that court concern. Next man.
Sir, I'm only requesting that the child. Sir, all his rights have been stopped by Honorable Supreme Court.
What do you want? Take down. This petition arises from judgment and order passed by the High Court of Delhi dated 20th of November 2024 in CM bracket M 1523/2023, CM application 48279 of 2023 with CM bracket M 2100/2024 with CM application 18875 of 2024 and CM application number 26720 of 2024 respectively. It appears from the by which the applications filed by the petitioner herein came to be partly allowed. Good point. It appears from the materials on record that The petitioner hearing. It appears that the dispute, this litigation appears to be one of a matrimonial dispute between the parties.
Something.
Good point. An application was filed by the petitioner under Order 18, Rule 17, read with Section 151 of the CPC for the purpose of leading fresh evidence and cross-examination of the respondent hearing, who is none other but his own wife. This litigation is pending in the family court, New Delhi. The litigation relates, this is under the litigation between the parties in the family court is one under the Guardianship Act. Full point. The High Court disposed of the applications accordingly. Good point. Having heard the learned counsel appearing for the petitioner and the respondent appearing in person, we see no good reason to interfere with the impugned order. Interest of the minor daughter. A view to put an end to this legal battle between the parties, we direct the family court to see to it that, what is the case number?
GP 48/12.
See to it that
48.
48.
the guardianship petition capital G-48 of 2012 titled Vinith Taneja versus Ritu Taneja is taken up for hearing and the same is disposed of in accordance with law without fail within 3 months from today. The disposal of guardianship petition G-48 2012 shall be reported to this court accordingly. Next matter.
Your Lord.
Thank you so much, sir.
There's only one issue as well.
Yes.
The grandmother, the second petition, which was CM number 2100 of 24, related to not visitation rights for me because I volunteered abeyance until I am to prove what is actually happened. My mother, who has been in the ICU, currently is back in ICU 82. Some visitation just on VC, let the daughter meet her one and only grandmother.
Sir, my daughter has been interviewed by honorable judges and she has expressed her views very clearly in front of them, in front of these counselors who were appointed.
We keep all contentions open for the parties to be canvassed before the family court.
Thank you very much.
My lord's permission if payment. That part.
Yes.
Both of us are here on the 16th. Your lordship's bench is also there next week. Can we be accommodated? It's a joint request. Next week, 16th. I just heard that my lord's bench is going to continue next week. That's what.
Beg your pardon?
My lords.
Yes.
Yes, my lords. And yeah, we heard that the bench is there next.
Heard anything?
Oh, that was my impression.
Whispers in the corridor.
No. That's what I heard my lord say. My mistake, my lords. But 16th, if it be possible.
16.
We are both here. And my lords, can I request if it can be kept on top of the board? It's a top of board. So,
Lords, may I mention?
Much obliged.
My lords, may I mention item number 50, wherein this honorable court has issued notice in the civil appeal today only, my lords. With that civil appeal, there is an IA for condoning the delay in refiling the civil appeal, my lords. It's 90 days only, my lords, which has not been mentioned during that time, my lords. If this honorable court may direct for condoning the delay.
That IBC matter.
Yes, my lord. Much, my lords.
Item 44, my lord. This is NEET PG matter, my lords. This was listed last week, my lord. Regarding this publication of answer keys, if my lord, there's some urgency, could have it next week, my lords. The counseling.
Go to next.
My lords, on item 44,
Yes.
item 44.
Actually mentioning is
Yes.
Allow him to complete now.
So, my lord, the counseling is starting on all the.
इसको 2 week के बाद top of the board पे लगा.
Very well, my lord.
Milords in item.
Nobody will speak from this side. It will go like this. Yes, sir.
Sir, in 43, I just needed 2 weeks time to file a letter.
Granted.
Milord, in 43 only, Milord.
Unlisted. May I mention a matter, my lord? Unlisted matter. That is SLP number 16661.
What do you want?
This is a demolition matter, my lord. This will be taken on Monday, my lord. My lord has directed us to. My lord has directed.
This quorum.
Yes, only this quorum. This quorum has passed on 21st August 2025 to demolish the encroachment part voluntarily by the petitioner.
Have you done it or not?
My lord, then meanwhile, Panchayat has passed a detailed order and stated that we have not made any encroachment and we have also
You managed it. Let the panchayat people be here.
Yes, my lord, responding number 5 and 6.
No, we directed you now. Are you supposed to comply with our directions or go by the order passed by the panchayat?
This is the Calcutta matter.
Yes, ma'am.
Disposed SLP, no?
No, it's not.
You are in contempt. You are in contempt, including the panchayat.
No, may I take a moment?
ये next week लगा दीजिए.
Lordship, what I am making.
Your Lordship.
Polished by the Panchayat authority.
Fine.
That's why I'm responding.
Have you complied with our order or not of demolition?
My lord, actually, it was,
You're not.
It was done by the demolition done by the Panchayat authority itself. My lord.
After our order?
Yes, my lord.
Then now what is the problem?
My lord, what happened, my lord? First, they have passed this order that Panchayat has been empowered to negotiate with us the encroachment.
Fine. You have demolished, correct? Make a statement on the next date.
Yes, my
Your Lordship, my humble apologies. I am mentioning, Your Lordship, item 44 again. Your Lordship, counselling for several states notifications have come. Your Lordship, 2 weeks time will be very late. Counselings will start and petitions will become futile, Your Lordship, because a lot of discrepancies have been raised in writ petition Meghraj Roy versus NB, Your Lordship. We have challenged the result also, Your Lordship. Your Lordship, humbly apologies.
What dusty?
That's why we can provide this order to Panchayat.
Again, you want to negotiate, you negotiate, get an order, then on the order you want to negotiate.
My lord, item 45, may I mention, it's an arbitration appeal.
Lordship,
The tribunal is in fact, currently it's stayed. The arbitration proceedings are stayed. So, my lord, give any short date?
Your Lordship, I am appearing for the respondent. I seek time to file the reply to the item number 4.
क्या हुआ अभी? Yours is 46, Ms. Narima. Not
Sorry? 45, my lord.
45.
45. In fact, it's been 4 months since notice was issued. It's
Your
still not
Lordship,
filed.
the client is from Agra, Your Lordship.
45 or 46?
Your Lordship, some time may be given to file reply, Your Lordship.
Are you all mentioning the correct matter, correct serial number?
Yes, item 45, Sunita Sachdeva.
Sunita Sachdeva is
Yes.
Virola.
Notify it after. कोई एक date दे दीजिए.
My lord, we have a small request. Ours is item number 42. Jagtaji infrastructure.
Please,
So if
it turns out to be a big request, then you.
it's a very small request, if you can put the matter for an early hearing, because it is a very small matter and it has already been covered by this honorable court's
I
judgment.
don't have any objection.
Okay, इसको भी कोई date दे.
My lords, may I mention item 47? My lords, item 47 is regarding the tender matter. I am requesting for next week, my lords.
You all can make a request. Arrest them also.
Hello, hello, hello.
Some judgments to be very much. You're going today.
We are withdrawing. Take liberty from the court as in terms of law to approach. And it's only with the liberty that for some reason, because I think they can drafted what I saw. Some. For some reason, it is. Otherwise.